Community TV's Court TV. I'm Ryan Hardy, your Crestview Community TV legal analyst, and today we're watching a miscellaneous court date / VOP court date. You're going to see, by VOP we mean violation of probation, and you're going to see a lot of people this morning a lot of them are going to be incarcerated because they violated their probation. When you violate your probation, you're not entitled to a bond. Doesn't mean you can't get one. It means it's harder to get one. On a new law violation, most people are entitled to a bond, absent some major circumstances. When you violate that probation, though, you're not entitled to a bond, but you can get one. But that leads this court date to having a lot more inmates. Now, when you're called to the podium, a couple things you can do. You can enter a plea to your VOP and say, yes, I did it, I violated my probation, and you can get sentenced. You can ask for a continuance. Let's set this down the road, maybe try to work out some details, maybe try to work out a deal. Or you can ask for a contested VOP hearing, which will be set at a later date in one of the afternoons of this miscellaneous date. Now,
okay, good morning. We're here on our miscellaneous docket day. Is Ms. Graham here? She's up first.
Good morning, Your Honor.
Good morning. Hold on a second. Let me get organized here.
No worries.
Too much paper. Okay. Very good.
Yes, Your Honor. I have two cases this morning. The first is Jennifer Hall in case 23CF1218. Unfortunately, we're unable to work out a resolution in this matter, and we're going to proceed otherwise. We have depositions scheduled for
We haven't
November.
listed as a status. It was just to come back.
We were hoping to resolve it with a plea, Your Honor. There were some unique circumstances with this case. We can approach if you'd like, but we do have depositions set.
So what do we doing? Just put it, continue it for another cycle as far as on the miscellaneous docket, or set it for, are you going to be setting for a VOP hearing?
Yeah, we have to see, it's a trafficking case, Your Honor. We have to see how the depositions go in November.
Okay.
But I believe you already have it still have it on the October pretrial docket. If you want to keep that there,
Put it
we'll
on
go to the
regular
next cycle.
pretrial, okay. What's the pretrial on October?
To the 14th.
Okay. So it'll be October 14th.
Thank you, Judge. The next I have Christopher Rogers. He has two cases, 23CF2116 and 23CF2466. We have come to resolution with this case, Your Honor. The state will be null processing case 2116 and a plea to 2466. However, this is a juvenile. He is in a commitment program in Ocala, so we need to make arrangements to finalize his transportation here and to coordinate with juvenile because he's in a commitment program and there's post-commitment probation, but they want to put him in adult probation.
In that situation, as long as I can put eyes on him through a Zoom here, I don't want to do an open court here.
Okay.
We could do it in chambers at the beginning of the thing. So if you'll coordinate, Eileen, I don't think there's any prohibition. As long as I can put eyes on somebody, I can swear them in. They have the right to be here. Is there any issue of not having counsel there present, or I'll transport them if that's what's required. I'm just trying to do what's.
Your Honor, I think that I don't think there's a prohibition of him pleading to these felony charges by Zoom as long as Ms. Graham can go see him and have him sign the plea agreement and go over stuff with him, but we are trying to get him transported back here so that he can appear in court here, and I think that would be helpful to Ms. Graham to actually meet with him in
So
person
he's
here.
over in Jackson?
In Ocala, he's in
He's in
Ocala.
Ocala at a commitment program.
Okay. Okay, well then, so what do we need to do today? We just continue this?
I think we kept on October docket, so we can keep that there. We can
Okay.
resolve it that day, or do you want it set for a special date?
So you want to do it on the 16th or the 14th? 16th?
He's in custody.
So it'd be October 16th pre-trial. And that'll, even though you're going to be null processing, we're not null processing today, that's part of the agreement, I see.
Yes, sir.
Yes, Your Honor.
Okay, so we'll continue both cases to pre-trial on October 16th. Okay.
Thank you, Judge.
Thank you very much.
That concludes my cases. May I be excused?
Thank you, have a nice day. Mr. Stewart?
Yeah, if I could pass mine.
Sure, that's fine. Mr. Shaw?
Good morning, Judge.
Good morning, Mr. Shaw.
I have Jaden Keith Bartley. There's 3 case numbers, Judges, all BOP.
Hold on, sir, let me. There you go. I'm sorry, go ahead.
2020 CF 945, 21 CF 148, and 21 CF 3288, I believe. Judge.
Correct.
Mr. Bartley was arrested again over in Wakulla County in the last couple of days. The state and I have discussed it, of course. This probably needs to be added to the BOP, so we'll ask to continue in the cycle, Judge.
Okay. So you want to come back on another miscellaneous, the next miscellaneous next month?
Probably about a month, 6 weeks out, Judge.
Okay, so, let's see. Today is the 12th. So you want to do October 22nd?
That'd be fine.
Okay. Continue it to October 22nd.
Thank you, Judge. That's all I have on the document.
Thank you. Have a good day. Mr. Sanders.
Good morning. I have Jacob Hudson in case number 23 CF 196, and the state is going to,
Whoa.
yes, sir.
I don't have that case. The only case I've got of yours is Hallmark.
Excuse me, Asher Hallmark. I apologize, that's correct. Case I've,
Go ahead.
23 CF 196, and the state is going to be announcing a dismissal on the condition that he pays an outstanding fee within 60 days.
So do we want to come back and make sure it's paid, maybe set it off 60 days, or you're, I don't know how you can dismiss it on a condition to pay something, because you got no leverage if he doesn't pay it. So I'm just trying to figure out procedurally how to do it.
The state would give him 90 days to pay the outstanding costs to the clerk of courts.
Or it would go to collections?
Correct.
So you're ready, you're willing to dismiss it now, he has 90 days to pay, or it goes to collections?
That's correct, Your Honor,
Okay.
to the clerk of courts. He has to pay.
Okay,
Thank you.
very good. So the court will order that, he has to, yeah, what are the costs?
It's $1,159.60.
And what is that,
It's a cost of supervision fee.
is that correct?
That is correct, Your Honor.
Okay, thank you, Madam Clerk. Okay, anything further we need to do on this case?
No, sir, thank you very much.
Okay, have a good day.
You too, sir. Thank you, ma'am.
Mr. Rare.
Good morning, Your Honor.
Good morning.
Your Honor, for the record, David Rare for Mr. Micah Chase Hagan for 19 CF 423. We're before the court on a motion for early termination of probation.
Which case is it?
Micah Hagan, Judge, and the firm's Lupella and Rare, so Micah and Lupella sometimes they get filed under the L names.
Well, I know it's always under Lapella, and I don't have anything for Mr. Lapella today on my docket.
And Judge, it might still be under Mr. Arrowwood. We recently took over that case this week. So we filed notice, I think it was.
What's the name?
It's Micah Chase Hagan, 19 CF 423.
Thank you. See one from Mr. See, I've got it under Mr. Shaw's name.
I think that might have been the prior counsel policy.
That's fine, that's fine. So, Mr. Lapella, it's under Lapella? Okay. Just trying to find it. Okay, go ahead now, start over again.
Thank you, Your Honor. For the record, David Rare for Mr. Chase Hagan, 19 CF 423. We're before the court on a second motion for early termination of supervision.
Right.
We're adopting the motion that was previously filed by prior counsel. Mr. Hagan has been on probation for a little over 4 of his 5 years.
I reviewed the motion. What's the state's position on this?
Your Honor, the state objects. The victim's position is that they are opposed to early termination of probation. We did not get to speak with the victim this time. However, on the last motion, that was her position that she had maintained from prior.
Okay.
And Your Honor, as far as probation, we did get an email response from probation, his officer, Ms. Michaela Shelton, verifying his conditions, completion, and how he's been on supervision. May I approach the copy to the court? I've already provided a copy to
You
the
may.
state.
Thank you. When was he placed on probation?
Judge, I have the exact date in front of me, but it was a little over 4 years ago, I believe.
And it was 5 years of probation?
Correct, with a withhold of adjudication on a lesser charge than the original charge.
I'm going to ask a technical question that I should know, but I'm going to ask you and embarrass myself a little bit. Is the termination of probation, statutory termination provisions discretionary or mandatory if they've done all the conditions?
So under the statutory scheme, there is a presumption in favor of the defendant. They've completed more than half their probation, everything's complete. There's a general presumption in favor of them. It is discretionary for the court. And I would note, as far as, can a person negotiate away their ability to petition for early termination or not?
I know that.
Case, right,
Yeah.
the original plea offer specifically included that he may petition the court for early termination. So he not only has a statutory presumption, he also has a written plea that guarantees the right to petition the court for this.
Does the state disagree with any of that, kind of the legal argument or anything else on that? Or you just stand mainly on the fact that, not mainly, but on the fact that the victim
That is
was
correct,
opposed
Your
to
Honor.
it?
Yes, and per the original plea agreement, he did waive statutory right to automatic early termination and can petition the court. So the state would have no argument.
I'm sorry, say that again?
In the plea agreement, it stated that the defendant waives his statutory right to automatic early termination, but may petition the
There
court.
is an automatic termination.
No, and I'm a little confused by the
There's no
language in the
statutory
original
automatic
plea.
termination of
No,
probation.
there is now in the current version of the statute a presumption after a certain period of time with a certain level of compliance. There's a presumption that the person should be entitled to that. But ultimately, it's still, in my reading of the statute, it's still ultimately the court's discretion, but there are presumptions and recommendations based on the model probation and completing things.
But you're saying that the plea agreement specifically said he has the right to seek early termination. She said,
Well,
he waives the right.
No.
I'm a little bit in.
It's the last sentence in the written plea. It says defendant waives statutory right to automatic early termination, which I don't know why that was written that way, because I don't think that's technically an accurate depiction of the statute. It's a presumption statute, not an automatic. But then the sentence continues, but may petition the court for early termination. So it was a part of the original plea at the time it was accepted and entered that he may petition for early termination of probation. Independent of that, he would still have a presumption at this point with what he has accomplished. And also the court does have discretion to do so.
Hold on a second, let me look at something. Court's going to deny the motion. We need to go ahead and finish up probation.
And Your Honor, just because the court was reviewing something, I asked what the court was reviewing, was it the statutory provision?
No. We're reviewing the file.
Understood, Your Honor.
Okay. Thank you very much. Ms. Merrifield, is she here?
Judge, if I could have just a few more moments.
Sure.
Thank you.
Mr. Stewart, you still want to, well,
I believe Mr. Kilpatrick.
Mr. Kilpatrick seems to be quiet. Come on up here, Mr. Kilpatrick. You're here and
Well, Judge, I was
you want
8 o'clock, you know, I just didn't sign up.
oh, you got to sign up the forms. So you were here, but you didn't, and you didn't just bust into the queue. Well,
No, sir, I didn't.
Give you
I
that.
did not. I apologize. Next time I may. But before the court, Keith Kilpatrick represented Maggie Keeley, case number 24 CF 1868. She is present as she approaches the lectern. We're here for a bond modification. After speaking with the state, we've come to an agreement with regards to the bond. I believe that the state is agreeing that her bond be reduced down to $10,000 cash or professional. As a condition of her bond, she'll be given random UA and breath tests. She'll be wearing a scram monitor. She'll have to attend one AA meeting a week. No drugs or alcohol without a prescription. That is the agreement.
That is the state's agreement, Your Honor.
very good. Based upon that agreement, the court will grant the reduction in bond pursuant to the terms of the agreement between the parties.
Thank you very much, Your Honor.
We need to.
Should I submit
that
that?
in writing? Yeah, we
No
do.
problem.
We always want to have it in writing.
I will articulate that and put it in writing and send it to the court.
Okay, thank you very much. She can still get out based on the clerk's minutes, but we need to get an order just to paper the file, just to make sure we're all
Yes, sir.
clear on it.
Yes, sir.
Thank you. Mr. Stewart, you ready?
Yes, sir.
Good morning.
May it please the court, Your Honor, Brad Stewart, on behalf of Matthew Scott Allen, Judge, this is 23 CF 1933 and 24 CF 1200, Your Honor. Judge, we are before the court with regards to an early plea. I do have a fully executed plea and sentencing agreement along with the score sheet. May I approach?
You may. Thank you.
Your Honor, at this time, Mr. Allen is prepared to tender a plea of no contest as it relates to 23 CF 1933. Mr. Allen is pleading to a lesser included offense of possession of controlled substance with intent to sell or distribute. That's a second-degree felony, level 5, Judge. The remaining cases and counts are as charged, and the terms are as follows. It'll be a withhold of adjudication, Judge, 36 months of drug offender reporting probation concurrent between all cases and all counts. He must attend and complete the Phoenix House inpatient program as a special condition of supervision, Judge. He will be transported to the program from Okaloosa County Jail in as much as bars to bed. Appropriate fines and costs, that's $1,140 and $615 respectively. It will be subjected to random urine analysis, no drugs or alcohol without prescription. He may travel for work purposes and adjust curfew as needed for work purposes. Judge, I'm going to ask the court to waive cost of supervision based on the length of incarceration and the length of the Phoenix House program. That's 18 months, Judge. And that concludes the totality of the agreement.
Your Honor, that is the state's agreement. This is not a downward departure based on the reduction, and the court should have the score sheet. So that
And
is the
the
state's
defense is okay with the score sheet, I assume?
Yes, Your Honor. No objections, deletions, or additions.
Mr. Allen, would you raise your right hand, sir? Do you swear or affirm the information you're about to provide this court is the truth and nothing but the truth, so help you God?
Yes.
So you heard your attorney state the terms of your plea agreement, and I see those same terms are contained in the written plea agreement that you have signed. So I just want to make sure, have you read the plea agreement closely and gone over it in detail with your attorney?
Yes, sir.
We had all your legal questions answered regarding this plea agreement.
Yes,
Because by entering this plea agreement, this will be a final resolution of your cases. But in order to get here, you gotta waive some valuable legal rights. The right to force the state to prove their case and confront with all those constitutional rights you're waiving in order to get a final resolution. Just wanna make sure that's what you wanna do.
Yes, sir.
Did anybody threaten or coerce you to get you to enter into this?
No.
Based upon that, the court will accept your plea. The one, I am gonna make just one comment. I know, you've gone over this, and what I'm gonna say probably, doesn't really matter, because, you've already gone through a lot to get to this point. But this is a second-degree felony, 15-year max, okay? Which means, if you've got a chance to do this.
I appreciate it.
But if you violate this, the potential downside is much higher than just a regular 5-year felony,
Yes, sir.
third-degree felony. I just want you to be aware of that. You're by entering this plea agreement, it's good. You're getting out. You can get to the Phoenix. You can get your stuff done. But I just want to give you all the incentive you can. This is your shot. You need every day you need to get up and fight through it every day, because there's going to be days you're going to want to run. Because that's the way it is. Addiction's a difficult thing to overcome. We want you to be successful.
I appreciate you giving me a chance to.
You just gotta, this is gonna be tough. You gotta start right here. And it can be somebody else doing something for you.
Right,
That's something I've really learned since I've been on this side of it. It's gotta start right here.
right.
Okay.
I'm
The
doing
court
my best.
will accept the plea agreement, and there'll be a withhold of adjudication on the lesser included offense, as well as the charged offenses in the possession of paraphernalia and the possession of controlled substance that are in addition to the lesser included offense. But, okay. We've got to slightly amend this, because the 1129, the misdemeanor, the possession of paraphernalias, the max is only 1129, and you've sentenced him, I assume all of them are concurrent.
That would
in
be
all
1120,
counts.
it would be 1129 concurrent on
Yeah.
the misdemeanors.
Yeah, you gotta put that in here.
May I first?
Yes. Because your maximum sentence on the 2 misdemeanors is 1 year, 1129. So you're gonna, the way it was worded is you're getting 36 months on all the counts. But 2 of those counts is too much.
Right.
You only get, you'll complete those misdemeanors after a year. And then you'll continue with it. It has the same effect of the 36 months.
So just read it in. So if you want to initial right here, just put the letter that starts 29.
Yes, ma'am. Sure.
Curfew, you want the curfew to be regular 10 to 6, or is there a different curfew?
Well, it's not included in here, so I would assume it's the standard curfew. Is that, Mr. Stewart?
That is
Good
what's-
question, thank you.
Yeah, Judge, that's what's contemplated. It's also contemplated it may be adjusted in accordance with work.
Phoenix House.
Once he gets into the work program.
Okay, is that sufficient, ma'am?
Yes, yes.
Okay, thank you. So, based upon a slight revision of the 1129 probation for the 2 possessions of paraphernalia charges, the other 2 charges, all of them are be withhold of adjudication, but on the 2 felonies, you're sentenced to 36 months, drug offender probation, concurrent, which means they'll run together. As a condition of that drug offender probation, the defendant must attend and complete the Phoenix House inpatient program. That's a special condition, obviously, of the supervision. The defendant must be transferred from the county jail, bars to bed. So you're going to be going right directly there, not don't pass go. Standard court costs $1140 and $615. Those will be payable during the term of the probation. Random UAs, no drugs or alcohol, obviously without a prescription. and you may travel for work purposes and adjust the curfew as needed for work purposes. And you, court will waive the cost of supervision. Okay? Any questions? Even though you're just entering into this, you do have 30 days to appeal it.
Thank you, Your Honor.
Thank you.
That's all I have for the court. May I be excused?
You may.
Thank you.
Mr. Scott?
Good morning, Judge. Chris Scott here on behalf of William Hable, case number 24 CF 1057. And Your Honor, Mr. Hable and the state have entered into a PTI agreement that we would like to present to the court today.
Very good.
May I approach?
You may. Okay. So I think Chris, would you raise your right hand, Mr. Hable? Is that how you pronounce your last name, Hable?
Yes.
Mr. Hable, do you swear or affirm the information you're about to provide this court is the truth, nothing but the truth, so help you God?
Yes, sir.
So, Mr. Hable, you heard your attorney state, he didn't actually spell out, there's a couple of different ways you can do pretrial intervention programs. This is kind of a hybrid, because you're actually entering into a plea, and the pretrial intervention is a condition of that plea. If you successfully complete this, and there's no reason you can't, then it'll discharge, you'll get the charges dismissed. But if you don't, what makes this a little bit of kind of a hybrid is that you come back directly to sentencing. So you're admitting to guilt, okay, if you fail to complete the PTI. Do you understand that?
Yes, sir.
Okay, and you've had a chance, I assume, well, you've signed the plea agreement, so I assume you've read it and you have gone over it in detail with your attorney.
Yes.
Okay, and you understand by entering into this plea agreement, you're waiving the rights, some rights, the right to have the state prove their case and confront witnesses and other constitutional rights. You believe that's in your best interest here today?
Yes.
Okay, do you have any questions?
No, Your Honor.
This is the state's agreement, I assume? You've signed it, but...
It is, Your Honor.
Well,
That is the state's agreement. I apologize.
They got to tell me.
That is
Yeah.
the state's agreement.
Okay. Now, do we need to, who do we need to give the pretrial intervention? Does that both go to the clerk?
I believe that we need to go to probation.
I think so. Thank you. Any questions, Mr. Scott?
Your Honor, is the court going to set any recall dates on this?
Usually, yeah, that's a good point. Usually we come back in 6 months. The PTI, do you set a kind of status review of the PTI or?
Not a PTI.
Okay.
If it fails to comply with this return to
Okay, they'll, if he fails to comply, they'll just put it on the document.
Thank you, Judge.
Thank you.
That concludes my business.
So, Mr. Bowman, and then Mr. Catalinic, you didn't get to sign up, but you're next.
Yes, sir. Thank you, sir.
Sure.
Good morning, Your Honor.
Good morning.
Blake Bowman on behalf of Ignacio Bartolo. That's case number 24 CF 956. Your Honor, this one we pled to a misdemeanor plea at the last court appearance with JCS. I reached out to his translator for an update, and he's set to meet with their Spanish-speaking probationer on 9/17. Wasn't too sure why it was set for a status call today.
And Your Honor, there is a written plea agreement in the clerk's side.
So why is this on the docket? Shouldn't be.
It should not.
There's notes in the case, plea agreement sentence does not match the charges filed in the case. It does not specify which count to no cost after amending the charge on count one. I guess that's why it's returned to the docket.
That's interesting. Your Honor, we can get that squared away right away and sent off to the state and refiled.
Okay, so what do we need to do here today?
Set it for another control date, Your Honor, to have that turned in.
Okay.
Yes, we will do that, Your Honor.
Okay, so we'll come back on You want to come back in a month or next week?
Probably come back next week, Your Honor. I anticipate we'll be able to get that squared away way ahead of
We'll just
time.
continue until the 17th.
Thank you, Your Honor.
Okay, thanks.
That's all I have, Your Honor. May I be excused?
You may,
Thank you, sir.
Mr. Cadlin?
Your Honor, can we pass my case for a couple of minutes?
Sure. Sure, Ms. Merrifield?
Thank you.
Not yet, Judge.
Okay. We've got a few defendants that are here without attorneys. Why don't we do their cases first? I'm just make a general statement for those, because there's a half dozen or so of those folks that are at least on my docket. Those that are here on without an attorney, this is probably, most of them as I'm looking through the docket, this is your first appearance on a violation of probation. That's like a new charge. So this is an arraignment. So the purpose of today's is basically just to make a plea if it's your first appearance on a violation of probation. So what I'm going to do is I'm going to ask you, when you come forward, I'm asking you to come up to the podium, ask you if you want an attorney. You always have the right to have an attorney. In some cases, you may have had a discussion with the state to have a resolution of this case, even without an attorney, but I'll ask you some questions if that's the case. So if you'll come down when I call your name, and we'll resolve these quickly. Mr. Kane Fuller, would the state announce?
Yes, Your Honor, this is 23 CF 316. Mr. Painful is here for a violation of probation, Your Honor.
So, Mr. Fuller, as I said, you have the right to have an attorney. You wish to have an attorney appointed?
I ain't really got the funds for that right now, but I did want to talk to y'all about.
No, you don't want to talk to me. That's not, what you want is an attorney. The attorney will help you. I can't help you here today. And you're only going to be charged a little bit of money for a public defender. You're not going to be charged much. You can go, I'm not going to force you to have an attorney, but I need you to respond first. Do you want to have an attorney appointed? Yes.
Yes.
Okay, court will appoint you the public defender. I thought you were leaning that way. Court will enter a denial. And the reason why I'm entering the denial on your behalf, so that preserves your rights, so you can talk to your attorney and tell her everything you want to tell me, and maybe she'll have some motion or something she can help you with, okay? So stay in good contact with her. Gage Hall.
Your Honor, this is Mr. Gage Ryan Hall, case number 23CF1007, here on a violation of probation.
Okay. So again, Mr. Hall, you heard my statements. You do have the right to have an attorney appointed. You have to have an attorney appointed.
No, we already came to an agreement.
You got
Your
an
Honor, the
agreement?
state had a discussion with Mr. Hall. We came to an agreement.
Okay.
I will read the terms of the agreement.
Okay.
It's
Do
admit
you have an
violation.
extra copy I can be looking at? Or if you just have one, just go ahead and read it.
I will bring
That's
it
all
right up.
That's fine.
Admit violation of probation, revoke and terminate on count 2 only, which was a misdemeanor. On count 1, modify and extend for 1 year, complete any outstanding requirements of original terms, automatic early termination upon completion of requirements, and a $100 VOP fee.
Okay. Does that sound like the terms of your agreement?
Yes, sir.
Okay. I'm going to bring it to Mr. Hall so you can sign.
Okay. I just need to ask you a few questions to,
There you go.
okay, go ahead. Has he signed it? No?
You don't sign it, right?
Okay. You got to sign the agreement.
Your Honor, may I approach?
You may. Thank you. So the count 1 is the driving on a suspended?
That's correct, Your Honor. That was the felony
And
charge.
then the DUI is the misdemeanor?
Yes, Your Honor.
Okay. Okay, Mr. Hall, would you raise your right hand? I just need to ask you a few questions. Do you swear or affirm the information you're about to provide this court is the truth and nothing but the truth, so help you God?
Yes, sir.
Okay, so, Mr. Gage, you heard the state, and the state's, it's not your attorney, they're obviously on the other side, but she outlined the terms of the plea agreement, and those terms are contained in the written plea agreement that I see you just signed, as did the state. Have you gone over this plea agreement, read through it, make sure you understand what it is?
I got what's going on, yeah. I
Okay,
understand.
you're comfortable that you understand?
Yeah.
Because by doing this will be a final resolution of case. It's obviously pretty straightforward, it's a good deal.
Yeah,
But you are waiving some rights to get here and just want to make sure you're doing it freely and voluntarily.
Yeah, I understand what's going
You
on.
feel like you understand what you're doing even though you don't have an attorney?
Yeah, I'm great.
Okay. Based upon that, the court will accept your plea. There'll be an admission of the VOPs on both VOPs. The court will revoke and terminate as to count 2 only. And so that probation will be finished. That's the misdemeanor probation. As to count 1, which is the felony probation, the court will modify and extend for an additional year. So whatever was the end point, you're extending it for 1 year. And all the outstanding requirements of the original terms are still in place, okay? You've gone over them with your probation officer, and you can ask her any questions about that. You will be able to, as a part of this, receive early termination upon completion of all requirements. And
Okay.
part of those are an additional, of course, I always got to get you for fees, $100 for VOP.
Yeah, I got you.
Any questions?
Yeah, I'm good. I just
Okay.
realized what's going on.
Stay in good contact with your probation officer.
So probation will speak with you about the terms.
Yes, sir. You ready? Yes, sir. Okay.
Your Honor, Wendy Catalytic, on behalf of Mr. Parker, Jameson, Gorea. Mr. Gorea, come forward, please. Your Honor, we haven't reached a resolution in this case. There's 3 case numbers, 21 CF 2985, 20 CF 2356, and it looks like 20 CF 2010.
Hold on a second. I've only got one. I've only got you up on one of them. All I've got is the VOP 2020 CF 2010, 2010. Not 2010, 2010.
That's better.
I don't know, where's the other cases? You just named 3 cases, didn't you?
I don't know.
Did you announce some other cases?
Yes, sir, I did the
I
case
just
numbers.
want to make sure we're dealing with all of them, because I only have one of them on here.
Back in June, he was originally set with 3 cases.
I have 2.
2. She's got 2, Your Honor.
And the clerk's got 3, but you just named 3. Why don't we go over what are the 3 case numbers, Madam Clerk?
Judge, I have 21 CF 2985,
Okay, hold on. 21 CF, what's the number again?
2985.
2985,
I got 20 CF 2356,
2356, okay?
and 20 CF 2010.
Okay. The only one on my docket is the 2010, but we'll deal with all 3. Now with that, go ahead and proceed.
Yes, sir. Your Honor, we're basically asking for continuance. There's a jail sentence that's involved here, and we think we can do some things to work that out and modify that. So we're asking for a short continuance on that.
Okay. A month?
A month is
Is
good.
that good?
Yes,
Okay.
sir.
So we'll continue this, put it on the next pretrial docket in October, October 17th, 9 a.m.
That's good.
Yeah, this is a VOP. These are VOPs.
What's that?
All these are VOP cases.
I know, that's why I put them on this way. What did I say? These are VOPs, it's on the VOP docket. I said the right date, but I called it the wrong.
That's
wrong
fine.
time.
I would have
So
figured
it's
that out.
October 17th at
Thank
9
you, Judge.
a.m. It's on the miscellaneous docket. These are VOPs. And we'll do all 3 of them, right, Madam Clerk? So you'll track all 3 of them together.
I appreciate
Okay,
it.
thank you, Judge. Have a good one.
Bye-bye. You too, sir.
Ms. Merrifield, are we good? You ready?
No, Judge.
You're not
Waiting
ready?
on- I'm waiting on ASA Sharpless.
Okay.
I got 2 minutes.
Yeah, we'll do the pro se inmates, then we'll start with regional conflict and the
Your Honor, this is State versus Jeremy Cox, case number 22CF3028, and 23CF2758.
Okay. So, Mr. Cox, these are new violations of probation applied based on the new law charge. This is like an arraignment hearing. This is your first hearing on the VOP. You do have the right to have an attorney appointed in these new cases. My first order for ask for your plea is to ask if you want an attorney.
Yeah, are these brand new charges?
Well, there are violations of probation, which are technically new charges. Yes.
Okay.
So you want an attorney? Yes?
Yes.
Okay.
Thought I had one.
Even if you have one, you gotta have it appointed on the new attorney. So I'll appoint you the public defender, and I'm gonna go ahead and enter a denial on your behalf. That just preserves your rights and gives you a chance to meet up with your attorney. We will continue this until next month, October 17th at 9 a.m. Okay? And you'll meet with your attorney in the interim. Mr. Jones, this is a violation of probation. This is the first hearing on a violation. It's 21 CF 1620. So I told the gentleman just before.
Your Honor, he was found incompetent to proceed in 24 CF 1327. The state would stipulate to carry that on to this case.
We should appoint first, right?
That's up to the court. The court could also find, or just take judicial notice of that report in the other case, and find him incompetent as well here. Then up to the court.
I always just want to have an attorney.
Yes, sir.
So, of course, what I'm going to do, Mr. Jones, you've got the other case, and so we're trying to work with that. Let me go ahead and appoint you an attorney so he can help you navigate your way through this case, okay?
Okay.
And Your Honor, given that there is the outstanding order in another case, and I think the court signed it less than a month ago, we would simply ask the board to take judicial notice of that order previously signed for
Do
this
we have a
case.
case number on that?
Yes, Your Honor, that's 24 CF 1327.
And the court will take judicial notice of the competency order in 24 CF 1327 and find him not competent to proceed in this case as well.
Thank you, Your Honor. That way Mr. Jones can get the treatment, okay?
Okay, thank you. I think we have one other out of custody that is without an attorney. Is Candy Burwanger here? Candace Burwanger.
And Your Honor, that is 23 CF 1320, and I'm checking for notice right now, Your Honor. I apologize for
Okay, thank you for doing that.
that. Off of there.
We're waiting for Ms.
It does look like she did post bond, Your Honor, and it looks like
I'm
there
sorry.
was, she did post a bond for the bondsman, and it did have the court date on there, I think. but it does look like the mail to her came back undeliverable, but I do know that the notice also went to her bondsman, you know.
So the notice was for today?
Yes, the notice that went to the bondsman in the state had September the 12th on it. The mail that went to her came back undeliverable, but it did have today's court date on it.
So, what is the state?
Your Honor, the state would ask for capias for failure to appeal.
Court will issue no bond. I also have one other case before we work with the regional conflict. Jacob Arnold with Ms. Gooden is, it's got here for a change of plea, so I'm just wondering whether
Your Honor,
somebody's been in communication with Ms. Gooden and what's going on.
Ms. Gooden and I have spoken, and we do have a misdemeanor plea that she sent me the plea agreement, and we had to change it. So it's to misdemeanor, so that means while she's not here today, I will get with her and ask her to
So we
file.
can continue this matter, and then you'll, in anticipation of a misdemeanor plea, and it'll
And
come off the
extension.
docket at that point,
We
right?
can do a plain extension, Your Honor, yes.
Okay. So on Tyler, which is 23 CF 2030, we'll just continue this until next October 17th.
It's currently set for October 14th. Would you like me to reschedule it to the 17th? Or just leave it set for the 14th?
You can leave it set to the 14th. Very good. So, Mr. Harper, come on down.
Yes, sir.
Is there, before we, is there anybody that's here that thinks they have a hearing that has not been called that's out in the audience? Okay, Mr. Harper, come on.
Judge, I have two out of custody. If I
Okay.
can address those first. The first being Jonathan Dodson, number 21 on the docket. He's present and approaching. Judge, we had set this. This is case number 23 CF 1719. We had set this for status today, just to see if we can come to a resolution. If we can bring him on the October pretrial conference, we're not able to come to a resolution today.
Okay.
So,
So we'll continue until October 14th, pre-trial at 9 a.m. So,
The next one, Judge, there's a waiver of appearance. This is Brian Hicks, 23 CF 1904. Judge, I think this was set today in error. If we can just, he's already set for the October pretrial conference. If we can set him for today, I think it was, for some reason, set for a motion hearing, but there's not a motion pending.
well, as a matter of fact, as I was prepping it yesterday, I was looking, I had a big question mark, and I couldn't find it either, so we're all on the same
I think we're all
lost
pointing
page.
the finger at each other.
Okay, so we'll just make sure this back on the regular pretrial docket on October 14th.
Yes, sir. The remaining two cases are in custody, and I do need to
You need to
talk
talk
to
to
the
them.
state.
Okay, so we'll,
Thank you.
we could have brought them out if you're ready, but we'll go ahead and wait. Okay? Ms. Farkas, you want to start with some of yours?
Yes, Your Honor. I think the first one I have on the docket is James Calvert. He is present and approaching. There are three dockets, 2022 CF 308, 2022 CF 284, and 2022 CF 1220. I've already been in contact with the state about this case. We have an offer, but we'd like to enter a denial, so I have time to speak with my client about the offer.
Okay. Enter a denial and we'll come back next month. That work, October 17th?
Yes, that's great, Your Honor, thank
October
you.
17th at 9 a.m.
be, well, I guess my next out of custody would be Armand Culbreth, but he is not present. I spoke with the state attorney about this case. Mr. Culbreth was prepared to take a plea today. He lives in Mobile, and with the weather, I'd ask that we excuse his appearance. I'll file the waiver.
We all have to deal with hurricanes.
I know. I have been in constant contact with him, though. He's never had any issues on pretrial services or anything. So I'd like to waive the appearance and continue it.
Miss Eileen emailed me regarding this defendant, and he said he is on his way.
Oh, cool.
Traffic's just really bad on the interstate.
Okay, so then I can
And
just
by
set
the
it
way, I
aside.
was just kidding. A hurricane is a good excuse for a court.
Thank you. I'll keep that in mind. Okay, so we can just put it aside, and when he gets here, we'll handle it. I believe that everyone else I've got is in custody for the
Okay.
moment.
Mr. Medina, would you have
I'm
any out of
in
custody?
custody, Your Honor, and I'm working on an agreement or two, and I think maybe there's nobody for me to call right now.
Okay.
I'm gonna be finishing drafting a couple of agreements. I've already sent one back, and then hopefully this.
So we want to take a short break here this morning, and it looks like we don't have any that are ready. Do you have one?
No, Your Honor, just before the court leaves the bench, I have something on another matter, if I may approach, but it's
You may.
nothing with here. We don't need everybody.
Pardon?
We don't need everybody. This is just another case that's coming.
That's fine. You don't need the defense counsel?
Hello, this is Chris Norman at Bulldog Bail Bonds. Our office is in Crestview, Florida, but we service 7 Northwest Florida counties. If you ever find yourself in a jam, please give us a call. We're here to help you out.
Congratulations, Crestviews' very own Dixie Dan Powell of Powell Injury Law, for your recent jury verdict of $11.5 million for your client from a death and injury against an inflatable amusement company. Recognized in 2017 as one of the top 100 civil trial lawyers in the state of Florida, and Dixie is AV preeminent rated. Dixie Dan Powell works tirelessly for his clients, as is evident by this extraordinary verdict. If you're taking your case to trial, be prepared. Contact Dixie Dan Powell and Powell Injury Law, 850-306-2667.
Okay. Mr. Harper,
Back Home Bakery Cafe is 2 blocks from the courthouse on Crestview's historic Main Street. We serve handmade pastries, espresso, and lunch items. And we're open Tuesday to Saturday from 7 a.m. to 4 p.m., serving lunch from 11 to 2. We hope to see you soon.
Hello, I am Bonnie from Body Be Healthy here in Crestview. We have been serving the area since 1999. We're an alternative health food store. If you're interested in bettering your health, we'd like to invite you to stop by. We're located in Court Plaza. Stop by and let us help you be healthy.
I'm Amanda Gaskin with Briar Patch Realty. Helping qualified heroes save money is my passion. When I help a hero buy or sell a home, they receive a check from Homes for Heroes. Check out amandasheroes.com for more information.
For more than 70 years, the sweet aroma of the Crestview's Coney Islands burgers and hot dogs has permeated the downtown area. If you have not experienced the unique flavor of Crestview's Coney Islands burgers and hot dogs, then I encourage you to join us for lunch. Monday through Thursday from 10 a.m. till 3 p.m., Friday from 10 a.m. till 4 p.m., and Saturday from 10 a.m. till 2 p.m. We're located in historic downtown Crestview at 107 North Main Street. Call 850-683-1045.
CQ Roofing, your hometown roofer since 1999. We're state licensed and insured,
family owned and operated with 24 years of local service. We specialize in shingles and metal, re-roofs, repairs, and leak specialists. For all of your roofing needs, call us today or visit our website at cqroofing.com. CQ Roofing, your hometown roofer.
Hey, I'm David at Family Vision of Crestview. We've been providing excellent optical service for Northwest Florida for over 34 years. Come in and let us take care of you.
Man, I got this. Let's roll.
Fight fire with fire, take one.
Have you been injured in an accident and need righteous representation? Call us, because we fight fire. Damn thing ain't working. Whoa! Not cool, bro.
I'm attorney Coy Browning. Personal injury is no joke. Just ask him.
Injured? Take a breath. Call Coy.
Check out the soaps, bath bombs, and other bath and body products, all made by hand with natural ingredients at Hub City Soapery. Visit us at 1092 North Verdon Boulevard in Crestview or shop online at hubcitysoapery.com. Hub City Soapery.
This is Tiffany Woodham, State Farm's newest agent in Crestview. I'd like to personally invite you to stop by my office for a no-cost policy review. Let me help you start saving today. Call in, walk in, or click in at yourcrestviewagent.com.
Alex Barthay from the UPS store once again, and I wanted to let you know about our Sunday hours. We're open now 7 days a week. Normal hours that you've been expecting, but now we're open Saturday 10 to 4, Sunday 10 to 3, and it's both our Crestview, Fort Walton Beach, and Eglin Air Force Base locations. So you have things to do, go and do it. Just know the UPS store is going to be here. Again, Sundays 10 until 3 p.m.
For years, I proudly served Florida as a state trooper. During that time, I investigated over 1,000 car, motorcycle, and trucking crashes. My mission was simple, to help the victims. Now, as an injury attorney, I can do even more to help accident victims. Hi, I'm attorney Coy Browning. If you've been injured in a car accident, I'd be honored to help you. Call or visit us at browninglawfirm.com.
Hi, I'm Wanda Roberts. For the last 20 years, I've been helping the residents of Northwest Florida buy and sell their properties. My office is just 1 block south of the courthouse in historic downtown Crestview. Give us a call at 850-398-5389.
Hi, I'm Michael Gilbert, defense attorney with Warrior Law. I represent those accused in Santa Rosa, Okaloosa, and Walton County. If you or anyone you know has been accused of a crime, give us a call. We can help.
Hello, this is Chris Norman at Bulldog Bail Bonds. Our office is in Crestview, Florida, but we service 7 Northwest Florida counties. If you ever find yourself in a jam, please give us a call. We're here to help you out.
Congratulations, Crestview's very own Dixie Dan Powell of Powell Injury Law, for your recent jury verdict of $11.5 million for your client from a death and injury against an inflatable amusement company. Recognized in 2017 as one of the top 100 civil trial lawyers in the state of Florida, and Dixie is AV Preeminent rated. Dixie Dan Powell works tirelessly for his clients, as is evident by this extraordinary verdict. If you're taking your case to trial, be prepared. Contact Dixie Dan Powell and Powell Injury Law, 850-306-2667.
Back Home Bakery Cafe is 2 blocks from the courthouse on Crestview's historic Main Street. We serve handmade pastries, espresso, and lunch items, and we're open Tuesday to Saturday from 7 a.m. to 4 p.m., serving lunch from 11 to 2. We hope to see you soon.
Hello, I am Bonnie from Body Be Healthy here in Crestview. We have been serving the area since 1999. We're an alternative health food store. If you're interested in bettering your health, we'd like to invite you to stop by. We're located in Court Plaza. Stop by and let us help you be healthy.
I'm Amanda Gaskin with Briarpatch Realty. Helping qualified heroes save money is my passion. When I help a hero buy or sell a home, they receive a check from Homes for Heroes. Check out amandasheroes.com for more information.
For more than 70 years, the sweet aroma of the Crestview's Coney Islands burgers and hot dogs has permeated the downtown area. If you have not experienced the unique flavor of Crestview's Coney Islands burgers and hot dogs, then I encourage you to join us for lunch. Monday through Thursday from 10 a.m. till 3 p.m., Friday from 10 a.m. till 4 p.m., and Saturday from 10 a.m. till 2 p.m. We're located in historic downtown Crestview at 107 North Main Street. Call 850-683-1045.
CQ Roofing, your hometown roofer since 1999. We're state licensed and insured, family owned and operated with 24 years of local service. We specialize in shingles and metal, re-roofs, repairs, and leak specialists. For all of your roofing needs, call us today or visit our website at cqroofing.com. CQ Roofing, your hometown roofer.
Hey, I'm David at Family Vision of Crestview. We've been providing excellent optical service for Northwest Florida for over 34 years. Come in and let us take care of you.
Man, I got this. Let's roll. Fight fire with fire. Take 1.
Have you been injured in an accident and need righteous representation? Call us, because we fight fire. Damn thing ain't working.
Whoa! Not cool, bro.
I'm Attorney Coy Browning. Personal injury is no joke. Just ask him.
Injured? Take a breath. Call Coy.
Check out the soaps, bath bombs, and other bath and body products, all made by hand with natural ingredients at Hub City Soapery. Visit us at 1092 North Verdon Boulevard in Crestview or shop online at hubcitysoapery.com. Hub City Soapery.
This is Tiffany Woodham, State Farm's newest agent in Crestview. I'd like to personally invite you to stop by my office.
Ms. Merrifield?
Yes, Judge, I'm ready. Like Mr. Kilpatrick, also here at 8 o'clock. It just took me a little bit longer to get things wrapped up. So I apologize.
That's all right.
All right. And Judge Brady Merrifield, on behalf of Corey Michael Bowen, 24 CF 1554, if the court could give me just a moment to get a signature. And you did read everything. Okay. Can you reach that? Today's the 12th. May I approach, Your Honor?
You may. Thank you. Thank you.
And I apologize for the handwriting, Judge. I tried to make it as clear as possible.
That's all right. You're better than some. Go ahead and announce the terms of the agreement, please.
So in 24 CF 1554, Mr. Bowen is withdrawing his previously entered not guilty plea. He's entering a no contest plea. He does have 4 charges. It's important to note that count 1, he is pleading to the lesser included offense of battery, domestic violence, and first degree misdemeanor. I have cited the appropriate Florida statute. It would be, and just before I read everything out, count 2 will be the felony, so that will be the main charge that kind of encompasses a lot of the different terms and everything concurrent, Judge.
Very good.
So in count 1, it's the lesser included battery, domestic violence. He is to have no violent contact with CMB. He would be on probation for 11 months and 29 days. That is going to run concurrent. He would have a substance abuse evaluation and a mental health evaluation within 30 days and complete any recommended treatment within 60 days.
Or begin treatment within 60 days.
Begin, yes, sir. Count 2 is going to be the only felony count. That is a criminal mischief. He is entering a plea as charged, and that is going to be 36 months of probation, $40 per month cost of supervision. He will have $867 in court cost. There is a restitution element. We are reserving that for 180 days for the state to provide information, and he is not to trespass at Waterscape. The address is 1110 Santa Rosa Boulevard in Fort Walton. Count 3 is a misdemeanor as charged. He is to have no contact with Danielle Klimzak other than for purposes of parenting their children. And the court can see that I've made a modification on that one.
Okay, hold on. That's a tricky one.
It is, Judge. So just
I understand what you're trying to accomplish, having kind of worked in this arena for a long time and understand the nuance. Yeah.
We are trying to provide some protections, Judge, to allow.
What I might suggest, if you get down in the weeds just a little bit, and for instance, one thing that's very beneficial is to have one of the parenting apps.
Yes, sir.
Or to at least agree only to communicate via text or email. But see, none of that's down there, so that means there's verbal communication, and inevitably we get he said and she said, and that's just not to protect her. I mean, I'm concerned a little bit about her, but it goes both ways. Protect you too, because if all of a sudden she says, well, he's calling up saying this, this, and this is not about parenting, and I want him arrested.
Understand, Judge.
You know,
we are trying to be a little careful, just so the court is aware. There is no Chapter 39 or DCF action in the state of Florida. All these parties live outside the state. We are unaware of any pending DCF or Chapter 39 style action in another state. These are divorced people with children in common, and Mr. Bowen is seeking private counsel to assist him in family matters to help alleviate some of those concerns. So whereas we would have talking parents, I am not sure what would be available to Mr. Bowen for communication.
I'm going to accept this plea agreement here today, but I'm going to strongly suggest to you, for your own protection as well as for hers, that you consult with an attorney and maybe try, if you had something, an agreement, only to use certain types of communication, only to do certain things. In other words, you have something clear. Clarity always benefits everybody. When you have, even forget the court hearing, an agreement with somebody. What you want is you want a clear agreement. The purpose of the clear agreement is to avoid conflict. Exactly the same here. The more clarity you have, the less chance there is to have conflict. He said, she said. Anyway, so I'm going to accept this, but it's not as clear, but it's not anybody's fault that it's not clear. You need to get something, whether it's formally filed in the divorce proceeding or just some written agreement. So when you talk to an attorney, you tell them the judge said he really recommended that we get something in writing, something clear, so that both parties can be protected. You can use my exact words if that's helpful to you. But it's tricky when it's out of state and everything. We don't have as much control. Anyway, go ahead.
He would also have to complete and show proof of the batterer's intervention program. Under count 4, that is as charged. It is a misdemeanor. There is to be no contact with Clifton Davis. It is 11 months and 29 days of probation. Also concurrent. It's important to note that all counts will run concurrently, so it's a total of 36 months. I did articulate in the agreement that he resides out of state. We've already communicated with probation related to the transfer, and that probation will be transferred and supervised upon approval from Mr. Bowen's home state. This is to be adjudication withheld. And then he also does understand that any contact with the minor CMB, which is the only minor that was associated in a charged offense, would also be pursuant to any Chapter 39 style court that may happen in other states. Again, Judge, we're just trying to provide those protections so that if there is an action, he would have to abide by that as well.
Just point of clarification, because just the way it's worded, it says all counts run concurrent. I understand what that means, but then it says for a total of 36. It's not a total of 36. It's really the longest of them is 36.
It is, Judge.
It's not, total means aggregate, and it's not an aggregate.
And I did try to articulate each count to be concurrent with all the different ones.
You did right up until that last sentence, but I understand. I don't think we have to change it, but I just, as we're talking here, it's not a total of, it's basically each of the counts, you basically have 3 1-year probation and 1 3-year probation, but they all run together. So at the end of a year, 3 of those probations will have concluded, terminated. But that one is going to continue to go for another 2 years. That's the way it'll work. You understand that?
Yes, sir.
Is the state in agreement with this?
Yes, that's the state's agreement.
Okay, so Mr. Bowen, would you raise your right hand, sir? Do you swear or affirm the information you're about to provide this court is the truth and nothing but the truth, so help you God?
Yes, sir.
Okay. Is Marcy's law been advised?
Yes, it has.
Okay, so Mr. Bowen, you heard your attorney state the terms of your plea agreement. It's a pretty in-depth plea agreement, and you all did a good job of trying to work out the details. It's a little bit complicated when you have family and children and visitation and all that stuff. So, but I see that same plea agreement is contained in the written plea agreement. I'm trying to find the signature page to make sure everybody signed. Everybody signed it. So my first question to you, Mr. Bowen, have you read the plea agreement closely?
Yes, sir.
And have you gone over it in detail with your attorney? Make sure you had all your legal questions answered regarding this plea agreement. Just in this exchange, you can see there's a lot of nuance in this thing. So do you feel like you had all your legal questions? Do you feel like you understand what you're getting into here?
Yes, sir.
Are you entering this freely and voluntarily?
Yes, sir.
You understand this will be a final resolution of your cases here. But in order to get here, you got to waive a lot of rights. The rights are mainly constitutional rights, right to go to a trial, right to force state to prove their case beyond a reason. All that stuff you're waiving in order to get a final resolution today. Is that what you want to do?
Yes, sir.
You believe that's in your best interest?
Yes, sir.
Okay. And the state is in agreement with this?
Yes, Your Honor.
So based upon that testimony, the court will accept your plea agreement. Count 1, it'll be you're pleading to a lesser included domestic battery, which is a misdemeanor in the statutory size contained in the plea agreement. And as to this count, there'll be no violent contact. That means you can't have contact with CMB. I'm assuming that's a minor.
Yes.
Is that your child?
At all?
No. Listen to me.
Yes, sir.
That's all right. That's a good question. If you have any questions, I want you to note them and ask them, and even interrupt me. No violent contact. So what that means is you can have you can't have violent contact anyway. It's really nothing, but it's just like putting you on notice. Say no violent contact. You get any, you're in trouble. Okay, it's going to alert people to watch out for that. So, but again, you're not allowed to have violent contact anyway with mine or anybody. But I assume is this your child?
It is. Both of them are, Your Honor.
Okay. And so the sentence on this count 1 is 11 months, 29 days. And again, all of these are going to run concurrent. And there is, as a condition of that probation and some of the other probations, you must submit to a substance abuse and mental health evaluation within 30 days, and recommended treatment must begin within 60. Count 2 is the felony charge, and and that's the criminal mischief, and you're pleading as charged. And there'll be a 36-month probation, $40 a month cost of supervision and standard court costs. There is a possibility of restitution, but the state's gonna have to file something, and you have the right to argue it or deny it, and have counsel. There has to be a hearing. And that'll be reserved for 180 days. It's important, this no trespass at Waterscape on Santa Rosa Boulevard. On count 3, as charged, again to the misdemeanor, 1129 probation, concurrent with counts 1 and 2. And on this count, you must, as a condition, is batter's intervention. You got a lot of services, so you got a lot of work to do here on this thing. No contact with Danielle Klimchak. I assume that's the mother of your child?
Yes, sir.
Okay. Other than contact dealing with parenting purposes, as we said, try and get something in writing on it. Were you all married?
I was divorced in 2012.
Okay, so you were married, child was born while you were, so I assume there's a divorce and there's a parenting, we call it a parenting plan down here in Florida, but there's some order,
Yes, sir.
court order? Okay. That's where you might want to get your attorney to have some clarification or, tighten it up a little bit on the communication to limit that, just so everybody's clear. And you can sell it to the other side because it's for her protection as well as yours. So, but pursuant to this agreement and to deal with the criminal side, no contact other than contact for parenting purposes. So you can call her and talk to her about the parenting stuff, although I might suggest that you try to limit all in person and try and do it, but that's not a part of this. So I just got to be clear what you're being bound to technically here and suggestion. The other one's a suggestion. This is no contact other than contact for parenting. That's how it's worded. And count 4, which is another misdemeanor, no contact with Clifton Davis, and 11 months, 29 days probation for that. Again, they're all run concurrent with that one, it's 36 months. And this really doesn't have to be a part of it, but it is. Defendant understands that any contact with the minor is subject to any other, what we call a dependency. That's the Chapter 39 dependency court action. But somebody's got to take some, you would be made aware of it and be able to interact in that separate arena. Okay? You understand what I'm saying?
Chapter 39 is like.
Chapter 39 is the
court.
Yeah, if there's abuse, abandonment, or if somebody tries to,
It's what we talked about just a few minutes ago.
I got you. Yes, sir.
Adjudication withheld, Judge?
I'm sorry?
Adjudication withheld?
Is that what you're asking? Is that what's in here?
It was the only thing that wasn't announced, Judge, just running through.
Okay. I'm just looking for withhold of adjudication. There it is. Withhold of adjudication. I just want to make sure it was in here. Okay. Withhold of adjudication on all charges. Okay. Any questions, sir?
No, sir.
Okay. Good luck.
Thank you.
And the defense is okay with the score sheet?
Yes, Your Honor.
Not a downward departure?
It is not. And Judge, I do have one more case on the docket. It would be a plea in absentia. Brandy Merrifield on behalf of Tierra Allen in 24 CF 732. A score sheet is not required. It has been signed by the parties, if I may approach.
You may.
There's a signature page.
Thank you. This is a lesser, okay, 2 of the charges are dismissed.
That's correct. Gotcha. That is, Your Honor.
Okay. Very good.
And I believe that's all I have today, Judge. Thank you for your
Thank you very much. You have a nice day.
You too.
Okay.
Judge, I'm ready to go on my 2 minutes.
Mr. Harper?
I've got Marcus Clark and Roy Pate as well.
What's your second one?
The second one, Judge, is number 44 on the docket, Roy Pate. I think the public defender withdrew off of that case. I was appointed on that quite recently.
What's the name again?
Pate,
Pate,
P-A-T-E,
okay.
number 44 on the docket.
Okay.
Judge, first is Marcus Clark. He's before the court on 22 CF 661. What I'm asking the court to do is if we can bring Mr. Clark back next week. He's got another case that's currently pending in October. I think the state and I are trying to consolidate both into a global resolution. And I think we're very close. I think they have one thing that they need to confirm. And then we hopefully can bring this in for a landing next week, Judge.
Okay, so we'll continue until September 17th.
Thank you.
Thank you. And clerk, what do we got? We'll do it that day, but I'm 4-0.
This is Roy Pate. He's number 44 on the docket, 21 CF 2645. Judge, I was just recently appointed on this case. If a denial has not previously been entered, we would enter denial of the violation of probation at this time. And that's, we're still awaiting discovery. I would ask to move this to the next miscellaneous in October.
Okay. We'll continue, we'll enter a denial and continue the matter until October 22nd. What do we have, clerk, on
Thank you, Judge. That's all I have this morning.
Thank you. The October 17th and 22nd.
October 17th, 8th,
Who wants to go? Ms. Farkas, you're
Happy to do it.
technically first up.
I believe Sean Chaplin will be there.
Correct.
The docket, excuse me, is 2020 CF 292. Your Honor, this is Sean Chaplin. Excuse me. I'm speaking with the state attorney about this case today. We're going to enter a denial, but we are working towards resolving this one. So if we could just have a continuance today.
Very good. So we'll enter a denial and we'll continue this matter until October 17th. At 9 a.m.
Dawson. Dawson.
Your Honor, next is Yvonne Dawson, 2024 CF 1983. Mr. Dawson is here for a bond hearing.
Court has reviewed the motion. You want to make arguments?
Yes, thank you, Your Honor. So as you said, you've already reviewed the motion. Mr. Dawson, there are just two charges in this case. Mr. Dawson is just recently 20 years old. He's born and raised in Fort Walton Beach. His mother is here. She's waving. I've been in pretty constant contact with his mother. He has a lot of all his additional family is here in the Fort Walton Beach area. The charges alleged, of course, are serious, but just to speak to the specifics of the charge, there was no weapon found. The charge does allege that there was a gun involved, but there was nothing ever found. He was arrested as a result of a 911 call from the alleged victim. Like I said, Mr. Dawson is from the area. He has family in the area. I've spoken with his mother, who says that she would be able to put up $500 for his bond. That would absolutely max out her ability. Mr. Dawson has some money saved up from working prior to his arrest. Due to his age, he hasn't worked for all that long. But the most important thing, I think, to point out that is not included in the bond motion is that the alleged victim in this case, the same night, immediately after calling 911, is alleged to have gone and slashed the tires of the friend that Mr. Dawson was staying with. She now has an open criminal case, a misdemeanor criminal case. It's my understanding that she made a confession to the deputies in that case. I bring this up not to indicate that either of them, I guess to point out that neither of them really wants contact with the other at all. Mr. Dawson does not want to have contact with her. And I think that the fact that she was arrested immediately after calling 911 for something that's allegedly, it's a bit scary. The alleged victim in that case is not pleased, obviously, with what happened there. I think it indicates that the situation is gray at best, given the fact that Mr. Dawson has strong community ties, and that the facts of the case are not particularly strong. No weapon found, and the alleged victim's actions indicate quite differently to what she said to the law enforcement at the time. I'd ask that you consider lowering the cash or professional bond. He has never failed to appear for a court date. He has an open misdemeanor case, I believe, for petty theft, but that's it. He has he doesn't have any other convictions. There's no reason that he wouldn't come back to court, as he's very strongly refuting the charges. Given the family's limited ability to pay, I'd ask you consider a $5,000 cash or professional bond with pretrial services. He would be able to comply with a GPS monitor if your honor found that to be appropriate. But he is certainly unable to pay the current bond of $51,000.
Your Honor, the State Attorney's Office has had contact with the victim. She is not here today. She's unable to be here, but she did want the court to know that she does think that she is scared of the defendant. She did want the court to know that what's laid out in the arrest report is accurate as to what happened. She wanted the court to know that as it's put in the arrest report, that this is not the first incident. She is scared of retaliation if he does if his bond is reduced. And Your Honor, just to add, although what Ms. Farkas just brought up may be relevant, I think we all understand that in the practical, real world, just because someone has alleged to have committed a criminal charge doesn't mean that that the crime that they reported that happened to them is not true. So I would ask Your Honor to leave the bond set as it has been set by Judge Lockton.
Is the state in agreement, is the defense is saying there was no weapon recovered?
There seems to have been no weapon recovered, Your Honor, but it was some time before they made contact with Mr. Dawson. So I only say that to say that it's not like law enforcement immediately had contact with him after this incident.
Ms. Farkas,
Excuse me. No, Your Honor, just, of course, two things can be true at the same time, but I think the combination of everything that I had mentioned earlier, Mr. Dawson's age, the tenuous facts provided in the arrest report, and the fact that Mr. Dawson does not wish to have contact with the alleged victim anyway and would be more than happy to comply with pretrial services, I'd ask that you consider a bond that he could potentially make. The bond right now is tantamount to remand, so I ask you consider something lower. Thank you.
Court will reduce the main charge to $15,000 cash or professional as a condition of the bond. Obviously, no contact with the victim. And just to understand, on the no contact, it's important for the family to understand this. This is what I call a one-sided no contact. It's your obligation to stay away from her. technically, it's not her obligation to stay away from you.
Yes, sir.
So if she called you on the phone and you picked up, you're in violation. And on these type of charges, if you are able to post bond, these type of charges, you violate that. They pick you up, you will not get a bond. Just want to make sure.
Yes, sir.
And that also, there's something that's a little complicated to understand. It's called third-party contact. This is where the family comes in. So if the family contacts her, he's going to be put back in jail. So this is, you got to let this got to settle. You got to deal with this. That means stay away and no contact.
Yes, sir,
Are
I
there any
understand.
other conditions that the state is requesting other than no contact with the victim?
Your Honor, Mr. Dawson should not possess weapons while he is on pretrial services.
And that's, you know, okay.
That's fine with us, of course, Your Honor.
And the court's doing this partly because, you know, I mean, the juvenile's age, not juvenile, the young man's age, as well as the lack of record. So these things, you know, they become cumulative. So time for you to deal with this, get it straight, and be straight.
Yes, sir.
You got a chance. You're
I
a young
understand.
man. You don't have to go down. You don't have to go down. You've got plenty. As you well know, we got plenty of people in our county jail. We don't need another.
Yes, sir.
I mean that in all seriousness. We want you to be out. If you stay out, you got to be right. And I don't have to tell you what that means. You got to be right. Okay? Very good. Good luck.
Your Honor, his arraignment date,
Thank you.
excuse me, is October 17th. I don't know if we can just enter a plea of not guilty
You
now.
can enter a plea
Then we would like to do
not
that.
guilty on all charges, and we'll come back on a regular pretrial. Let's see, pretrial.
I think he's already set for 12/9, but I think it would be 12, well, I guess, if he posts bond, then it'll be adjusted.
You want to come for December? Is it December or so pretrial? Okay, so it's the 9th without, out of custody? So the first one is out of custody, December 9th is his date,
Okay.
if he gets out.
Yes.
But right now, you're in, so I don't know whether,
And Your
I
Honor,
would
I'm
leave it
sorry.
on the inmate day and then it can be moved if he.
that's correct. You're right, counsel.
Did Your Honor address the second count, the bond on
Hold
that
on a
one?
second, hold
Okay,
on.
I apologize.
So, December 11th, not December 9th, but you can change it if you get out. What's your question, counsel?
I'm sorry, there was a second count that there was bond also set in that charge.
Put
It's
a
just a
bond
petty
in an
theft.
ROR. What was the bond?
I think it was set at $1,000 specifically.
That's another special professional for the petty theft.
I'll just leave that as it is.
I'm sorry, Your Honor.
We'll just leave that as
Okay.
is. Okay. Thank you.
Thank you, Your Honor. Yeah, this is Matthew Elliott, 2024 CF 1969. He is also here for a bond hearing. The state attorney and I have discussed this case, and we've come to an agreement on a reduction of the bond. If Your Honor would approve it, the state has agreed to a $500 per count, so it would be $15,000 cash or professional total. With, of course, pretrial
Well,
services.
it's actually not. It's not a $15,000. It's a total, but you end up paying on each charge, so it has a fairly dramatic impact on how much he has to pay. There's a minimum for each one. So for each one, what is the minimum? 100, 150 for each one? That's not your normal 10% at 500. I just want you to understand Make sure you understand how it works. You understand what I'm saying, don't you, Ms. Bossa?
I understand what you're saying, Your Honor.
I don't mind doing it, I just want to make sure you're tracking what's going on.
Yeah.
You made a statement that
Okay.
it's technically not great, it's not a total, it's not a $15,000 cash or professional bond.
Right,
It's
yes, that's
20,
true.
whatever, how many counts of a $500
Correct. I think
cash
to
or
a-
professional, which have a minimum if you get bonded on it. So it'd be over twice as much of an actual bond. Just want you to be understand. Ms. Bossa understands what I'm saying, but do you?
Yes, I think that I was under the impression that if he's paying a bondsman and it's just the one case, that his family would be able to pay the $1,500
That is, I do
but is
not
that
believe
not
that's
true?
correct.
Your Honor, I'm not that familiar with the bond, I'm not even gonna, I thought it was a 10%, but we don't usually get involved with that part of it.
10% per charge.
Right, and that's, like I say, I'm not gonna weigh in on this.
In this particular case,
Yes.
because there's so many counts, it wouldn't matter if there were just 2 counts.
Right, I understand.
But if
Your Honor.
there's all these counts, it would
If-
result in more than twice as much of a bond.
Right.
I'm okay
If we
with it.
could, well, but Mr. Elliott's family is certainly not, they don't have that much money. So if we could pass this case so I can speak with Ms. Basso and perhaps we can finagle it so that the bond is set on only, that amount is on fewer counts. And so it's the same amount, but fewer counts, if you want to talk about it.
Maybe, why don't we slip them a little bit,
Yes.
since we've got them here, Judge, and maybe, I know the family has some limited means, and quite frankly, the state's more interested in the safeguards of pretrial supervision, the GPS monitor, not being around children. With that in place, we're actually very comfortable with any amount, because we don't have a reason to believe Mr. Elliott won't show. But the main concern is that we have the safeguards there that we usually ask for these types of charges.
If that's the case, I'm not sure if we could,
The state does not oppose a reduction in bond, Your Honor, to something that the family can make, as I said, as long as we have those safeguards in place, and also no internet access, please, given the nature.
yes.
So if the court wishes to address that and feels comfortable with an amount, the state will not oppose a reduction.
If somebody would help me with the figures, to determine what a cash or professional bond of approximately $1,500 would be, how we would structure it.
250 per count, perhaps? That would bring it, well, there, you're still doing
But
the
that's
minimum
still-
guideline, that's right.
It's so it has to be $1,000.
100 per count, right?
Right, so $1,000 cash or professional.
So what you have to do is have an ROR on some of them and count on others.
Alternatively, I don't know if the state or the court would feel comfortable with a signature bond. It could be a high, very high signature bond, like at the $15,000 amount. As Ms. Basso said, Mr. Elliott has multiple family members and friends here who are ensuring that he'll return to court. I've been in very constant contact with his sister and father. I truly do not believe that there would be any problem with a signature bond.
Right. I'm not gonna go to a signature bond,
Okay.
because that's not what the state has offered is reasonable.
If we could pass the case, I can try
Yeah,
to do
just
some.
come up with a calculation.
Yes.
You can have a combination of signature and the other. I appreciate you all doing the court had a lot of questions. You saved me spending a lot of questions, a lot of time
Thank you for
asking a lot of questions.
saving my
There's a lot of
life.
complications in that case.
We try to work together.
I understand. Who is this?
Who's this?
I'm sorry, this is Aaron Fain. There are 3 dockets, 2024 CF 1633, 2024 CF 690, and 2024 CF 707. The state and the defense have reached an agreement in this case. Everyone has signed it. If I may approach, Your Honor.
You may.
can, I'll be able to print out the updated score sheet and I can bring it up to the court
That's
in a little bit. Thank you.
Would you announce the terms of the agreement?
Yes, Your Honor. In 2024 CF 690, count 1 will be an adjudication of guilt, 24-month standard probation, which will be concurrent to all the other terms of probation, substance abuse evaluation within 30 days, any recommended outpatient treatment within 60 days, 24 hours community service, maintain employment, or submit 2 applications per week. Counts 2, 3, and 4 will be adjudication of guilt, credit for time served. Case 2024 CF 707 will be dismissed entirely. 2024 CF 1633, count 1 will be dismissed. Count 2 will be the same terms as the previous adjudication of guilt, 24-month standard probation, substance abuse evaluation and treatment, community service, and maintain employment or submit applications a week. Court costs and public defender fee, of course. Count 2 will be adjudication of guilt, credit for time served. So in the end, it's the 24 months probation and adjudication of guilt on the 2.
That is the state's agreement, Your Honor. The state will be dismissing 24 CF 707, and the state is in compliance with Marcy's law.
Pray, would you raise your right hand, sir? Do you swear or affirm the information you're about to provide this court is the truth, nothing but the truth, so help you God?
Yes, sir.
Okay, so you heard your attorney state the terms of the plea agreement, and I see those same terms are contained in the written agreement that you've also signed. So just want to make sure you read the plea agreement closely and gone over it in detail with your attorney.
Yes, sir.
Had all your legal questions answered about it?
Yes, sir.
This obviously will be not obviously, but it will be a final adjudication or final resolution of all these charges. In order to get here, though, you're waiving some valuable legal rights, the right to force the state to prove their case and confront witnesses, all the constitutional rights. You're waiving those in order to get to here. Do you understand that, and do you believe that's in your best interest to enter into this agreement?
Yes, sir.
And you have had all your legal questions answered?
Yes, sir.
Okay. And the state's in agreement?
The state is in agreement, Your Honor, and this is not a downward departure.
Based upon that testimony, the court will accept your plea, and the court will sentence you as follows. First of all, as to the state's dismissing count 1 in 24 CF 1633 and all counts in 24 CF 0707. And there are 4 misdemeanors, counts 2, 3, and 4 in 24 CF 690, and count, actually says count 2, but it's count 3 in 1633. You have 2 count 2s on here.
Oh, my mistake.
Make sure that you understand.
Yes.
And I don't think we addressed all the counts in 24 CF 690. There's
I know, I
total of 6
haven't finished. I did.
Oh.
I just
You-
made,
sorry.
just initially.
If you want to initial out the nomination. I got it. Yeah.
So on, again, counts 2, 3, and 4 in 690, and count 3 in 24 CF 1633, those are all misdemeanors. And on all 4 of those, there'll be an adjudication of guilt, and your sentence technically is credit for time served. So you're done with those. So the only thing you're really addressing today here as far as this plea agreement is count 1 in 690, 24 CF 690, and count 2 in 24 CF 1633. And they're both and in both of those cases, there'll be an adjudication of guilt, and you're sentenced to 24 months standard probation. They'll each run concurrent. They'll run at the same time. And both of those contain a condition that you must have a substance abuse evaluation within 30 days and begin any recommended treatment within 60 days. Community service hours and employment issues that have to be complied with, and standard court costs that must be paid during the term of the probation.
And just to clarify, it's a total of 24 hours community service and 2 applications a week, not double that. The terms of probation are identical and concurrent, so. We've had confusion before, so I just wanted to make sure that was clear.
Yeah, you need to clarify that. The way it says 24, it's for each count.
I'll just add that all
condition
terms.
of the substance abuse evaluation that can be done on each of the counts. So you got a chance on this one, Mr. Fain. Excuse me, Mr. Fain. A lot of charges are being knocked off in order to get you down to this 2 years of probation.
Yes, okay.
You need to take advantage of this. I will. You're not spring chicken. You need to get through this. You don't need to be. The jail's already full up, plenty good. Okay?
So I just wrote that all terms are concurrent.
Any questions?
No, sir.
You do have a right to appeal this, even though you just entered into this agreement. You got to do it within 30 days. Okay?
Yes, sir.
Good luck.
And landing.
Just reinstate it for 6 months. Have you sign?
Ms. Carter, we need to bring out.
Okay.
Hold on just a second.
Okay. I think they need to bring him back.
Hold on just a second.
So they might have you go stand over there.
Yeah, if you could just stand up.
Okay, thanks.
Deputy Stallings, yes, sir, you let Mr. Fain tell you. The clerk just pointed out to me that in 24 CF 690, there's 6 counts, not 4. So we only addressed 4 of them.
Hold on, 1 second. Are there 2 additional counts of possession of a controlled substance?
I don't know.
Is this what I missed?
Let me,
That was a jury counts.
So I just didn't put them in.
Yeah, just add them in.
Okay. So, Your Honor, I apologize. I need to add them into the plea agreement. If the terms will remain the same, so.
so what are we doing with those other 2 counts? Is
So-
they dismissed or?
No, Sorry, go ahead.
They will be included, Your Honor. And the same terms, just including those charges as well.
The 24 months on the felony counts and time served on the misdemeanors.
That's correct.
Yes. So I can edit it and bring it back up to the, I don't know if Mr. Fain needs to be here for me to.
Okay, so they won't change the terms of it.
Right.
You've got a couple other charges, but they're one misdemeanor and one. We need to bring it back out here. It needs to be clear.
Yes.
don't
I
wanna
apologize,
have-
Your Honor.
Bring something, I want to make sure you're clear what you're doing.
So, So I'll retype it up so that it's super clear, and we can bring Mr. Fain back if that's okay.
Okay.
Just so that there's no questions.
We'll get it all square, but we got to get it
Yeah,
clean so that you,
They'll bring it right back up.
so that everybody understands what's going on. Okay, just get it, you'll get it done here today.
Okay. Okay, this is Mr. Van Landingham, Michael, 2021 CF 598. This is a VOP. The state and the defense have reached an agreement in this case. If I may approach.
You may. Thank you. Would you announce the terms?
Yes. There are 3 VOP counts. The first one is a felony VOP, and the second and third are misdemeanor VOPs. There were previous adjudication of guilt on all charges. Count 1 will be admission of the VOP, reinstate probation for 6 months to complete the outstanding terms, automatic termination of supervision upon completion of all those terms, and the public defender fee. Counts 2 and 3 will also be admissions on the VOPs, credit for time served, revoke and terminate supervision. Those were misdemeanor supervision.
That is the state's agreement, Your Honor.
Okay. Mr. Van Landingham, would you raise your right hand, sir? Do you swear or affirm the information you're about to provide this court is the truth and nothing but the truth, so help you God?
Yes, sir.
So you heard the terms of the plea agreement, and I see you've signed the written plea agreement.
Yes, sir.
Just want to make sure you've read it closely and gone over it in detail. It's pretty straightforward. But you are waiving the right to go to a hearing and stuff by entering into this. You believe that's in your best interest?
Yes, sir.
And you have had all your legal questions answered by your attorney?
Yes, sir, I have.
Based upon that testimony, the court will accept your plea. There was previous adjudication on all counts. As to count 1, which is the felony VOP, the defendant is admitting the VOP, and the sentence is to reinstate probation for 6. So it's a new probation, reinstate for 6 months in order to complete any outstanding terms. You can automatically terminate it, the probation upon the completion of all those terms, and of course, they always get you with more fees and costs.
Yes, sir.
Counts 2 and 3, you're admitting the VOP as well, and the sentence is credit for time served on both of them, revoke and terminate probation. You're done with those, so you only have 1 probation left, that's the 1 felony.
Yes, sir.
Okay. Any question?
No, sir. She's been very thorough.
Thank you.
Thank you, sir.
Your Honor, my client, Mr. Culbreth, has arrived, but I want to go over the plea agreement with him, so if we could move on to my colleagues for now.
Very good. Would her colleagues like to come forward? Mr. Gates.
Your Honor, while we're waiting, may I approach about a different matter?
Sure.
Thank you.
A bunch.
Thank you, Matt.
Your Honor, this is going to be Mr. Jeremy Gafford. He's on both dockets, Your Honor. He's got the morning docket.
Okay.
And an afternoon docket case as well.
Okay, let me find his afternoon. Are we entering a plea?
Yes, Your Honor. We have a plea agreement to be filed. That's going to cover all 4 cases before the court.
Okay.
Getting signatures for the plea agreement, Your Honor.
That's the same thing it is,
Mm-hmm. And Your Honor, based upon the score sheet, this will be a downward departure. My expectations, the state's going to say it's for a negotiated plea agreement. It's a downward departure only in 24 CF 1863. In the VOP cases, 0513, 0514, and 05279, it's a modification, so no downward departure.
Is that correct for the state?
That is correct, Your Honor.
I can approach with the plea agreement.
You may. Thank you.
Thank you, Your Honor.
Would you announce the terms, please?
Yes, Your Honor. Mr. Gafford is going to be admitting the violations in 05 CF 13, 05 CF 14, and 05 279. Plea as charged in 24 CF 1863. He was previously adjudicated on all counts. In the VOP cases, I'll just summarize it, Your Honor. He's being modified and reinstated to probation. We're going to add the condition that he do an outpatient treatment program, preference through Bridgeway. That'll be scheduled within 60 days of his release, and he recommended treatment within 90 days of the evaluation, random urinalysis, $100 cost of prosecution in each case, $150 public defender fee in one, $100 public defender fee in the other cases. There was a Keaton requirement. I don't know if the court remembers Mr. Gafford. They sentenced him to Keaton. Unfortunately, upon arrival, they told him that he did not qualify for the program, which was a bit of a letdown for Mr. Gafford. But we're going to be removing that condition and requiring him to do the outpatient treatment through Bridgeway. Okay. And then the 24 CF 1863 is going to be 24 months of probation, concurrent, $615 court costs, and $100 public defender fee.
That is the state's agreement, Your Honor.
So no particular terms and conditions on the probation on 1863, just straight up probation?
Yes, Your Honor. He's going to be doing the requirements on the DOBs anyway.
Okay. Sir, is that the agreement?
That is the state's agreement.
Okay. Mr. Gafford, would you raise your right hand, sir? Do you swear or affirm the information you're about to provide this court is the truth and nothing but the truth, so help you God?
Yeah, I do.
Okay, so you know the routine, just want to make sure you've gone over, you can put your hand down. You've gone over the terms of this plea agreement. I see you've signed the plea agreement. Have you?
I went over this one. I read this one.
This is a copy.
I got the copy.
Yes,
I had just the same thing. I'm just,
Yes,
yeah,
sir.
that's a good point. You're paying attention. I appreciate that. So I just want to make sure you've gone over this agreement with your attorney. Make sure you had all your legal questions answered.
I do have a question. When
Ask your attorney, don't
Okay.
You can ask me if you
Let
want
us
to.
be on the record that when I leave out of here, I got this misdemeanor, but when I want to go, I don't want to do this, go to probation and get put back out on the streets in the same situation where I'm homeless and get on drugs. I'm 20 years behind. I just did 20 years in prison. I don't want to keep doing this. I don't want to violate anymore. So I want to leave here and go to the probation, and I want to turn myself into that JADA program. I can't, like, it's not my problem. It's not the drugs. It's the people, places, things, and like I have to go. So I don't know what to do. I mean, I literally don't even know how to work my phone.
And I understand, and as I told him before he came up, I've already talked to probation. Probation has just said as long as you check in with them and let them know what you want to do, they will help you try to get into that program. They will help you find a place to stay.
I'm just feeling like they're probably like tired of me. This is their, I keep this the same thing. I'm going out there getting on drugs.
I know,
And-
but
it's-
if they didn't want to do that, they wouldn't be doing what they do.
Okay.
All
Well, I thank
right.
you. I thank you. Thank you.
Oh,
No, I still got to ask you some questions. Just want to make sure you've gone over this with your attorney and understand what you're getting into here today.
I mean, you're emphasizing that. I mean, maybe am I wrong? I mean, what is it that, I mean, like.
Well, I just want to make sure, look, the big thing is, when you entered into this plea agreement, this is a final resolution of your case.
Okay.
All these, the BOPs and the new law charges. This is a final resolution, but in order to do that, you're waiving some rights. And they're all your constitutional rights, the ones you read about in the news. The right to a trial, the right to confront, these are constitutional rights. I have to ask you, are you clear that you're waiving those rights?
When you say waiving
I want to
those
make
rights-
sure, listen to me, I want to make
I'm
sure,
sorry.
I want to make sure you really want to do this and that you understand what you're doing. That's all I'm asking you questions. Do you understand all the legal ins and outs of this?
I think I understand, sir.
Okay. See, the main thing is, you come out, you've been in jail for a while, and you want to get out. I'll just sign anything. No, I got to ask you. I want to make sure you understand what you're doing, because I know it's frustrating, and we don't do a great job when guys and gals, when they get out. We don't. But we want to try, and whatever is out there, we want to try and give you an opportunity, because it doesn't do anybody any good, including us, including the other people, our community, to have you getting into trouble. We want you to be clean and good.
May I speak to you? May I say something?
Sure.
Okay, what I wanted to do is I wanted to come in here and just plea out to you, just because I just did this last year. I sat in jail 7 months and signed up for all these different drug programs that would help me. And they all denied me based on something that I did 20 years ago. I went to prison for 20 years. I've been tortured in there. I contracted the HIV virus from a tattoo. I paid my dues. I had 15 years probation. I keep failing a drug test, and not saying that the system failed me, but I am getting placed out there after 20 years. I've never had no money, no parents. I don't know nothing. So that's what happened. And none of these places, you sentenced me to Keaton. And I went to Keaton, and I'm there. I'm doing good. They're going to help me get a job. And then they say, hey, you know what? Your charges from 20 years ago got you messed up. You got to leave. Sent me back to probation. She emailed you, put me back on probation, regular probation, in the same situation. And here I am again. I wanted to come plea out you today and just ask you, can you just kill my probation and let me leave Florida, where I can go turn myself into a drug program in a state that will accept me and not hold what I did 20 years against me. That's what I want to do, but this is like the next best option, because I was told that that's not available. And I don't know. I don't want to fight with this. I'm not trying to fight nobody.
No, I understand. Well, let me just say to you, I'm being straight up with you. I'm trying to. I tried. You realized the last time I was trying to be straight up with you. You got a good attorney. He's walking you through this. If he's telling you something, he's not just trying to slough it off.
And that's why
He's giving you the best we got. And sometimes the best we got ain't all that good. And you're sitting here saying you want to try and be straight, and I believe you. Now, I also know that it ain't always easy, particularly when you ain't got any support when you get out. I get it. But probation's job is to try to, at least answer questions, try and point you in the right direction, and hopefully get some programs. I hope people do right by you, and I hope you do right by them.
I'm going to hold them accountable, because I'm leaving here and I'm going there and telling them I'm not leaving this probation office until you get me in some type of program, because I can't live out here. I
Just
refuse to
understand,
go back to
Mr.
the streets
Gafford,
and that.
one thing, okay? I'm not trying to be cute when I say this. Honey will attract bees a lot more than vinegar.
Oh, I didn't mean it in a bad way. I mean, she's going to know I'm
just
serious,
saying,
because, This will be my third time going
I
out there
know,
into the,
I know.
and it's the same thing. You get out there and there's nowhere to go but Walmart or the Tom Thumb, and there's a bunch of junkies out there holding up signs. I'm not doing none of that. They're all on drugs, but eventually people, places, things. I have nowhere to go. don't know what to do, and I get on drugs, and then I'm falling into that. I'm going to the probation office and I'm saying, hey, listen, I don't want to leave here and either Baker Act me or something, because I refuse to go to the Tom Thumb or the 24-hour laundry. I don't want to go there no more. Because it just leads to this. And I don't want to be in prison. Prison's not fun. It's hard. It's rough.
I agree. Okay. So the court's going to accept your plea agreement and modify and reinstate on the VOPs. Complete you got to plead a substance abuse evaluation treatment with Bridgeway, random UAs, standard fees. The key condition is removed. And the new law charge, you get 24 months of probation, just straight up, concurrent with everything. So hopefully you can get a good program and find some people that can provide some support as you're doing this. Okay?
Okay.
Good luck.
And, just so Mr. Gaffer's aware, I was letting probation know he does have another case that's going to hold him in, but they're going to start trying to see if they can't find a place or at least something for him when he does finally get out. They're going to try and be proactive about that as well.
I appreciate that. Thank you.
Good luck, Jerry.
Gillespie, when we next?
Your Honor, this is going to be Mr. Alex Gillespie before the court in 23 CF 1817. I don't know if the court remembers Mr. Gillespie. We were going to enter plea last month. He had some very, very good questions. The court asked me to continue the case so I could meet with him. I think I've met with him 4 different times since that court date to go over the plea agreement. I feel somewhat comfortable now that he's good with the terms. So I think we'll be on the entering a plea if I can approach with the plea agreement and score sheet, Your Honor.
Yes, sir.
Get a copy from Madam Clerk.
Thank you.
And no objection to the score sheet, Your Honor.
Okay, thank you. Would you announce the terms of the plea agreement?
Yes, Your Honor. Mr. Gillespie will be pleading no contest to the lesser included offense in count 1 of the offense in count 2. So essentially, he's pleading to count 2 times 2, if that makes sense, Your Honor. It's going to be adjudication of guilt, and count 1 will be placed in 48 months in the Department of Corrections with credit for all time served. Count 2 will be 5 years of probation consecutive to count 1. We're going to waive the cost of supervision for Mr. Gillespie. Standard court costs, public defender fee, $491 against crimes against minors. Defendant will not be designated as a sex offender. Sex offender evaluation within the first year of probation, any recommended treatment within 90 days of that evaluation. No unsupervised contact with any minors. No internet access or internet capable devices, and no social media.
That is the state's agreement, Your Honor.
Very good, Mr. Gillespie. Would you please raise your right hand, sir? You swear or affirm the information you're about to provide this court is the truth and nothing but the truth, so help you God?
Yes, Your Honor.
So just want to make sure, Mr. Gillespie, that you understand what you're pleading to. You can put your hand in. What you're pleading to, and that you're entering it freely and voluntarily. Obviously, as your attorney, you've got very experienced counsel, and he said, he's met with you multiple times. Have you gone over, I just want to make sure and hear it from you, gone over this plea agreement, had all your legal questions answered?
Yes, Your Honor.
And you believe that this is in your best interest to enter into this agreement?
Yes.
And you're waiving the right to go to a hearing and to force the state to prove their case. You're waiving those rights in order to get a resolution here today.
Yes,
is that what you want to do?
Yes.
Okay. You are entering this freely and voluntarily?
Yes, Your Honor.
Okay. Very good. Based upon that testimony, the court will accept your plea. And the count 2, which is going to be really for both of them, is an unlawful use of a two-way communication to facilitate a felony. That's the name of the charge. That's count 2, but it's also what's going to be now count 1 as well. And as to that lesser included charge on count 1, you're being sentenced to 48 months DOC with credit for all time served. And in count 2, you're sentenced to 5 years of probation, consecutive to count 1. So after you get out, you do have the probation, 5 years. Standard fees and costs, $491 fee for crimes against minors. And the defendant will not be designated as a sexual offender, but is required within a year of the first year of probation to have a sexual offender evaluation and follow through with any treatment that might be required. And that must begin within 90 days. And also, as a condition of the probation, it's the same as while you're in DOC, but also the condition of probation is no unsupervised contact with any minors, okay? No internet or internet-capable device and no social media, okay? You understand all that?
Yes, sir.
Any questions?
No.
Okay. And even though you just entered into this, after all this talking and whatnot, you do have 30 days to appeal it if you feel like you need to appeal this, because this is a sentence here today, okay?
Okay.
Okay.
Good luck. Madam Clerk.
Probation, standard probation or sex offender probation?
Standard probation.
Standard probation.
Thank you.
Mr. Howard will be next.
Your Honor, this is going to be Mr. Direct Howard. He's actually out again on both dockets. We've got him scheduled this morning in 24 CF 1765 as a bond hearing, and then he's scheduled for arraignment this afternoon. After speaking with the state, we have a stipulated bond that will submit the order later for Mr. Howard. The state's agreed to reduce both bonds, the amounts of both charges to $5,000 cash or professional. That's a total of $10,000. Pretrial services, GPS monitor set at the lowest permissible cost per day. And then I do believe the state had no objection to unsupervised contact with minors.
That's right.
So he would be allowed to have contact with minors. He's got 2 younger sisters that he'll be living with. That was the subject of that issue.
And Your Honor, given the nature of the charges and the age of the alleged victim in the case, we're not concerned about, like we are usually with the very young children.
So, we also entering a plea on this afternoon?
Yes, sir.
We're entering a plea, not guilty?
Yes, sir.
Okay. And we'll come back on that case.
My anticipation is if we can do the 14th, I'm anticipating him likely being bonding out later this week. October 14th, Your Honor.
October 14th, correct. I think we're doing December.
This one's already scheduled.
It's already set, so October 14th.
Yes, Your Honor. All of our arraignments are scheduled for the October pre-trial.
Okay. They're kind of at a point where some are going or something. So, and then the bond hearing, so all 3 of the, is they on the new law charge, or is each of, so there's 4 counts?
I have just 2 counts. The state only filed on 2 counts, Your Honor.
Okay, I'm a little confused. I'm just looking at I'm not looking at the document. So there's 2 counts on 1765 and then 2 counts on 17, oh, that's the same.
Yes, Your Honor.
Well, so you did a bond hearing on the one for this afternoon?
Yes, Your Honor, we did.
Ah, got confused. Okay, so there's 2 counts, 5,000 cash or professional.
Yes, Your Honor.
And again, the conditions are?
Pretrial services, Your Honor. It was the GPS monitor, and then also no unsupervised contact with any minors with the exception of the siblings that are in the home. There's no concern about that.
Yes, Your Honor. And let's set the GPS at the lowest amount per day. The state and I will follow up with an order here shortly.
Okay, so $1 a day?
Yes, Your Honor.
Yes, sir. And no contact with the victim.
No
I don't
contact
think we
with
said
the
that, but I
victim.
think we kind
No
of
contact
think
with
it goes without saying.
Yes. No, it's
We'll make sure we said it.
It's important to say.
Yes, Your Honor.
Okay. Thank you very much.
Thank you, Mr. Howard. October 14th, if you're out, okay? Hey, if you're still in, Derek, if you're still in, I'll come see you.
Mr. Howard finished for today.
He is, he's ready to go. Yeah, this is going to be Mr. Andrew Jennings before the court in 24 CF 610. He's also on the afternoon docket under 24 CF 1884. I have a plea agreement to follow in both cases, Your Honor.
Okay.
If I may approach, Your Honor.
You may.
I don't have a score sheet, but my expectation is that Mr. Jennings is not going to score more than 44 points. This should not be an departure.
Okay, thank you. Do you announce the terms of the agreement?
Yes, Your Honor. Mr. Jennings will be admitting the violation in 24 CF 610, pleading as charged in 24 CF 1884. We're going to maintain the withhold in 24 CF 610, modify, reinstate probation. Balance of supervision will be on drug offender probation concurrent with 24 CF 1884. Curfew will be from 7 p.m. to 7 a.m. Can be modified by parole and probation for work purposes. Complete original requirements, $100 cost of prosecution, $150 offender fee. And then a 24 CF 1884, count 1, 21 months of drug offender probation concurrent with each count, and 24 CF 610. Curfew will be from 7 p.m. to 7 a.m., but it can be modified for work purposes. Count 2, which is misdemeanor, a year of probation concurrent with each count and concurrent with 24 CF 610. 615 in court cost, $100 defender fee.
That is the state's agreement, Your Honor.
I know this is a real technicality, but on the misdemeanor count 2, is it drug offender probation? It doesn't say it, and I just find
Yes, Your Honor. My anticipation is I wasn't sure if we can do drug offender on the felony or on a misdemeanor, so I just ran it regular
just
probation.
regular. Okay, that's fine. Mr. James, would you raise your right hand, sir? Do you swear or affirm the information you're about to provide this court is the truth, nothing but the truth, so help you God?
Yes, sir, Your Honor.
Okay, so you heard your attorney state the terms of your plea agreement. I see those same terms are in the written agreement that you've signed. Have you read this closely, gone over it in detail with your attorney?
Yes, sir, Your Honor.
You want to make sure you've had all your legal questions answered regarding this?
Yes, sir.
And you believe it's in your best interest to enter into this? Nobody threatened or coerced you to get you to enter into this?
Yes, sir.
And you do understand you're waiving the right to go to a trial and other constitutional rights in order to get here today?
Yes, sir.
Okay. Based upon that, the court will accept your plea agreement, and on the felony violation, which is 24 CF 610, the court will modify and reinstate probation, and the balance of the supervision will be drug offender probation. And it will be concurrent with the new charges that I'll go over in just a second. Curfew is from 7 p.m. to 7 a.m., but it can be modified if you need it for work purposes. And complete original requirements, and then, of course, additional costs and fees. In 24 CF 1884, that's the new law charge. There's 2 counts. First count, you're sentenced to 21 months of drug offender probation. That's concurrent with the one I just announced in 610. Again, same with curfew, modified. And then count 2 is a misdemeanor, so it can only be 1 year. So it's 1 year regular probation. All of them are running at the same time, and all of them have the standard court costs and fees. And I assume that 21 months is trying to track it pretty much close in time. So hopefully they'll both be kind of running out at the same time. But they are a little separate, but they're running separate. They're running at the same time. Okay? Any questions?
No, sir.
Okay. Good luck.
Thank you.
Good luck, Andrew.
Thank you.
Did we skip Chris King?
What?
Christopher King?
He wasn't in custody. It didn't show on the list as he was in custody.
He is in custody. Can we get him?
King, yeah.
Your Honor, this is going to be Ms. Heather Garris before the court, 24 CF 1315. I left her today in hopes that we could get an answer from Keaton, which we did, and get a plea agreement resolved. Unfortunately, the state attorney has decided not to accept our offer of treatment. So at this time, we'll need to continue Ms. Garris' case to the October 16th date. She and I talked about potentials in order to maybe get the court to consider treatment, but I want to talk to her a little bit before we get on that path.
Okay. So this is 24 CF 1315?
Yes, Your Honor.
Okay. So we'll continue this? Next
October
month?
16th, Your Honor.
Okay. Continue to October 16th. 9 a.m.
Hall.
You know, this is going to be Ms. Carolee Hall before the court. We have a plea agreement to be followed if I may approach.
You may. Would you announce the term?
Yes, Your Honor. Ms. Hall will be admitting the violations in 20 CF 2457, State of Florida versus Ms. Carly Hall. The adjudication of guilt, we're going to revoke and terminate the probation. Essentially time served, although it's not listed there. $100 cost of prosecution, $150 defender fee. She'd ask for 24 months to pay those fees before they're sent to collections.
That is the state's agreement, Your Honor.
So what did you add that wasn't on here?
The court will sometimes say that it's time served, but it's not listed. That was the thinking on it, was just essentially.
But you're revoking and terminating probation.
Yes, Your Honor.
So that's the key. Ms. Hall, would you raise your right hand? Do you swear or affirm the information you're about to provide this court is the truth and nothing but the truth, so help you God?
Yes, sir.
Well, this is a real easy one because you've signed this and it's obviously revoking and terminating probation, so it's understand. Just
Yes,
want to
sir.
make sure you've gone over, had all your questions answered by your attorney, your legal questions relating to this.
Yes, sir.
And I'm sure you believe it's in your best interest because it's such a good deal.
Yes, sir.
Okay, based upon that testimony, state's in agreement.
That the state is in agreement, Your Honor.
So was there a previous adjudication of guilt or is that?
There wasn't, Your Honor. Ms. Gears was picked up in Calhoun County and was adjudicated and placed on 3 years of probation.
Okay.
So she'll be adjudicated this time with the
So the
sentence.
adjudication of guilt, the court will, for each of the 3 counts, will revoke and terminate probation, the standard cost of prosecution and public defender fee, and you'll have 24 months after you get out to pay those before it goes to collections, so you can avoid, you can get going after your driver's license.
Yes, sir.
Okay. Any questions?
No, sir.
Thank you.
Thank you so much.
Your Honor, this is going to be Miss Emily Hall before the court in 22 CF 1756. We have a plea agreement to be filed in her case, if I may approach, Your Honor.
You may. Thank you.
It'll be a modification, so that's where she will be filed in Ms. Hall's case.
Would you announce, please?
Yes, Your Honor. Ms. Hall will be admitting the violations before the court in 22 CF 1756. She's previously adjudicated guilty. We're going to modify and reinstate her probation. $100 cost of prosecution, $150 public defender fee, complete the original requirements.
State?
That is the state's agreement, Your Honor.
Ms. Hall, would you raise your right hand? Do you swear or affirm the information you're about to provide this court is the truth and nothing but the truth, so help you God?
Yes, sir.
You heard your terms, you heard your attorney state the terms of the agreement. I see you've signed the agreement.
Yes, sir.
And so you've gone over with him, had all your legal questions answered?
Yes, sir.
You understand that by entering in this, you'll be a final resolution of all these VOPs, all these cases.
Yes, sir.
You believe that's in your best interest?
Yes, sir.
You're waiving the right to go to a trial and all that.
Yes, sir.
You understand that?
Mm-hmm.
Okay, based upon that, the court will accept your plea. You were previously adjudicated guilty on all counts and cases. The court today will be modifying and reinstating probation on all 3 counts, standard fees and costs, and you must complete the original requirement. Okay, any questions? Thank you.
Thank you.
You know, this is going to be Chastity Jacobs before the court in 17 CF 3145 and 17 CF 3440. I have a plea agreement by Mayor Brookshire. You know, is it USC sentence? To the score sheet, it's a guideline sentence.
Would you announce the terms?
Yes, Your Honor. Ms. Jacobs will be entering a plea or admission to the violation of probation in 17 CF 3145, 17 CF 3440, previously adjudicated guilty in all counts of cases. In both cases, it's going to be the same sentence, Your Honor. We're going to revoke and terminate her probation. She'll be sentenced to 24.225 months Department of Corrections, concurrent with each count and case. That'll include credit for time served, including any previous time spent in DOC. The state stipulating that she has served the 24.225 months Department of Corrections and does not need to be transported to DOC. It would be eligible for immediate release. In the misdemeanor counts, it's going to be time served. $100 cost of prosecution assessed in each case, $150 public defender fee in one case, $100 public defender fee in the other case, $605 cost of transportation to the Okaloosa County Sheriff's Office, and then Ms. Jacobs would ask for 24 months to pay those outstanding fees before they're sent to collections.
That is the state's agreement, Your Honor.
Very good. Ms. Jacobs, would you raise your right hand? Do you swear or affirm the information you're about to provide this court is the truth, nothing but the truth, so help you God?
Yes, Your Honor.
So you heard your attorney state the terms of the plea agreement. I see those terms are written down and you've signed it. You can put your hand up.
Okay, thank you.
All right. I just want to make sure you've gone over with your attorney, had all
Yes,
your
sir.
legal questions answered.
Yes, sir.
I understand you're waiving the right to go to a trial for all this.
Yes, sir.
I understand why you're getting credit for time served, so it's
Yeah, I had a great attorney.
pretty clear agreement, and you are entering this freely and voluntarily.
Yes, sir.
For the record.
Yes, sir.
Okay. Well, based upon that testimony, the court will accept your plea in 17 CF 3148. The misdemeanor charge, which is count 2, is just credit for time served with standard costs and cost of transportation. The felony BOPs, actually all 4 of the felony BOPs, one in 17-3145 and then 17 CF 3440. There's a total of 4 counts. All those counts, they'll revoke and terminate probation, so you're finished with probation, and you're sentenced to 24.225 months in DOC, concurrent with all of these. So that's kind of your total amount. You will get credit for all time served, and in this case, in all these counts, the state is stipulating that the defendant, that you have already served that time in DOC or in some other incarcerative sentence, and you're eligible for immediate release. You do not need to be transported to DOC, and you'll have 24 months to pay all your outstanding court costs and fees, and try and do that because so that you can avoid them going after your driver's license.
So if I don't pay him, it will suspend my license?
Well, it's
I'm
not.
gonna make a payment plan.
Yes, that's probably going to happen, but
Okay.
we don't do it actually. Department of Transportation does.
Okay.
But yeah, if you don't pay these things, they'll track you down at some point and try and.
Okay.
It's the only leverage they got over you to try and pay these things.
Yeah.
So, but,
Well, I'm gonna make a payment plan as soon as I get home.
okay, good luck.
All right, thank you, Your Honor.
Yes, ma'am.
Your Honor, the only other one I had was Christopher King. It doesn't look like he was transported, but they're going to try to get him here for the 1 hour docket. It's an early
Okay.
plea.
Okay.
It's 2 inmates that we have to readdress and 1 out of custody person. It's totally up to you.
Mr. Denny, you want to do yours?
Whoever's ready in the queue, you know, I'm not going anywhere, Your Honor. I do have one person out of
Well,
custody.
let's do the out of custody if you got somebody out of custody.
Candace Berwinger is approaching. She doesn't currently have the public defender. but she's had a public defender in the past, and I know she's gonna fill out the application. Berwanger, I'm sorry, I don't have her case number or document.
Give me a
I
second.
thought we already addressed that.
Maybe you did, I don't know.
We did, Your
We
Honor.
entered a capias. but she
Yes,
wasn't
Your Honor,
here.
this is 23 CF 1320.
So you asking to withdraw the capias?
Yes, Your Honor, she would ask that we withdraw the case if she's here. I don't know if she had transportation. She did come over from Defuniak and there's bad weather, but I don't want to make misrepresentation.
Well, that's a pretty much a blanket excuse today with all the bad. We'll withdraw the capias.
Your Honor.
And right now I've got it where you're not, the PD is not appointed, so I'm appointing the public.
Yes, Your Honor, provisionally, and then she's gonna fill out the application, turn it in.
Okay.
I know it's probably gonna be a revoked offer. You gonna reinstate? Do you know what the offer is?
Reinstate to drug center probation with Keaton or Phoenix House.
Oh, but so she'd have to do Keaton or Phoenix House.
Yes.
Your Honor, so she's going to meet with me and go over her options, and at this time she will respectfully enter a denial.
Very good. We'll enter a denial here today. We'll come back next month, October 17th.
Thank you, without subpoenas. And
Without subpoenas, so make sure to meet up with your attorney in the interim, okay?
Yes, sir. Thank you. So call Karen. Okay.
Okay.
Go ahead.
We can do my out of custody client Armand Culbreth, 2023 CF 1247. He is present and approaching.
Okay.
The state and the defense have reached an agreement in this case. I've gone over it extensively with my client and I've signed it, if I may approach,
You
with
may.
the score sheet as well.
Would you announce the terms, please?
Yes, Your Honor. The one case, 2023 CF 1247, Mr. Culbreth will be adjudicated guilty on counts 1 and 2. They are identical counts. Count 3 will be dismissed. Both count 1 and 2 will be 5 years sex offender probation with all the standard terms and conditions. These will be done consecutively, so will be a total of 10 years probation. So 5 years on each count consecutively. Sex offender designation, GPS monitor at $1 a day. No contact with minors, no devices capable of internet access, no internet or social media use. Court costs, which I might have gotten the court cost wrong, so I apologize in advance if that is not right. We were all guessing a little bit. And then the public defender fee, of course.
What are the court costs? We've got 867, is that correct?
That's correct. Nice. Okay.
We got lucky, Ms. Farkas. Mr. Culbreth, would you raise your right hand, sir? Do you swear or affirm the information you're about to provide this court is the truth and nothing but the truth, so help you God?
I do, Your Honor.
And Ms. Farkas, you're okay with this portion?
Yes, Your Honor.
Okay,
I've been over it with my client as well.
very good. So, Mr. Culbreth, you heard your attorney state the terms of your plea agreement, and I see you have signed the written plea agreement. Just want to make sure you've gone over it in detail with your attorney here today?
Yes, Your Honor.
Had all your legal questions answered?
Yes, sir.
And you understand that by entering into this plea agreement here today, you're waiving the right to go to trial, force the state to prove their case and all that?
Yes,
This will be a final resolution of your case here today?
Yes, sir.
And you're entering this freely and voluntarily?
Yes, sir.
Nobody threatened or coerced you to get you to enter into this?
No, sir.
Okay, based upon that testimony, the court will accept your plea. And as to count 3, the state's in agreement with this and dismissing count 3?
That is correct, Your Honor.
Okay.
Stays in agreement.
Your Honor.
I'm sorry? What did you say, Ms. Bassam?
No, I was just agreeing though, no pause on count 3.
Okay, no. Okay, so count 3 will be dismissed, as the state just said. And counts 1 and count 2, which are identical counts, will have the same sentence. It'll be adjudication of guilt on both counts. And the defendant is sentenced to 5 years sex offender probation with all the standard terms and conditions. And these will be consecutive, so it'll be a total of 10 years sex offender probation. There is a sex offender designation, and a condition of the probation will be GPS monitor, will be at lowest rate, which is $1 a day. And as a condition of that probation, no contact with minors, no devices capable of internet access, no internet or social media access. Okay, do you understand all that?
Yes, sir.
Those are important conditions, because if you violate those conditions, their state's pretty hard about coming back on you, and they'll be looking at DOC
Your Honor,
sentences.
Mr. Culberth wanted to make a brief statement to the court, if he
Welcome to
may.
do so.
How you doing, y'all? First off, I'd like to apologize for being late today. There's excuses that I can make, but I should have been here earlier. But as far as this case is concerned, I also would like to apologize for being in this position and having the state go through all this process and spend all this time on this case. And I take full responsibility and accountability for my actions. And this was a isolated incident, a dumb mistake that I shouldn't have made. But I own up to it, and I'm looking forward to putting this behind me someday. Until then, I'm gonna do my best to comply with the terms of the probation and not have this happen again. And thank you for this opportunity. Thank you.
Thank you. Well, the one thing I'm gonna, my bit of advice sounds not very unique, but the best way to be successful on these probations is to make sure to make good contact with your probation officer. Your probation officer needs to be your new best friend. It's a cute saying, but really, work with them and make their job easier. And, 'cause 10 years is a long time to be on this thing, and you're gonna have to kind of get used to it and kind of get involved with the rhythm of it so that you can be successful, okay?
Yes, sir.
Okay, good luck.
And then you're going to speak with probation when you're done. Yeah.
So whoever's in the queue. We can proceed with.
What are we doing with
whatever
Elliot?
inmates come out, we've got several inmates.
Okay, let's do it.
Yeah, so I have Van Landingham, Fain, and Elliott who need to be readdressed.
Put Ms. Farkas in the,
Yeah, let's do yours, then you can. So which one are we doing first?
Whoever shows up first.
Well,
Yes, sir, you're all gonna be in there. Very good one.
Let's do Van Landingham
Yes,
first.
ma'am.
Like two flashes here. There was an issue with the probation for Van Landingham, so that's why we're bringing him out again.
okay,
So nothing's really gonna change, but.
okay.
So, Your Honor, Mr. Van Landingham, I spoke with probation, and both of us missed that his probation on count 1 was also expired. It had terminated. It was past due. So we're simply going to revoke and terminate the current term of supervision, sentence him to a new term of 6 months. So exact same outcome. He'll just complete the outstanding terms and automatic termination upon completion. Everything else is the same. It just has to be a new term of probation. Yeah.
So just want to make,
Yes, sir.
so just want to make sure you understand this minor little change here.
Yes,
but
sir.
Have you had a chance to talk to your attorney about it?
Yes,
Any
sir.
questions?
I just didn't finish my DUI class in time, so it's pretty simple, straightforward.
Okay, very good. So the court will initiate these, order these changes as contained and stated by the defense counsel.
Thank you very much for the opportunity, Mr. Ketchum. Thank you, sweetheart.
Elliot?
This is Matthew Elliott with the bond situation on 2024 CF 1969. Ms. Basso and I discussed that I think the easiest thing would be just for the first 15 counts to set the bond at $1,000 cash or professional per
Okay.
count. So it'll be the same, the total of 15,000 cash or professional. And then the remaining 15 charges, either ROR or a signature bond, whatever the court feels is appropriate.
Along with the conditions that we discussed earlier.
Yes, of course, I apologize.
I'm sorry?
Along with the conditions that we discussed earlier with the pretrial supervision, the GPS, the no contact.
Right. Well, I mean, that's fine, 1 through 15, we'll have $1,000 cash or professional, and the remaining counts, actually 16 through 30, will be $1,000 signature bond. And why don't we just make sure and restate the conditions on each one of these bonds?
Yes, sorry, Your Honor. So counts 1 through 15 will be $1,000 per.
And 16 through 30 will be $1,000 signature.
Right, and then the terms will be the GPS monitor. I don't know if there's just the lowest possible cost per day.
That'll be $1 at the lowest.
Yes, and pretrial services and no contact with minors.
And no internet.
No internet, yes.
No internet.
And Mr. Elliott's family, they were here earlier, they were here all morning, but when they learned what the bond was, they left. They're gonna take care of it, so that's why they're not here anymore. But they're still very involved.
So you understand, no contact with minors, that's important. You understand that? And you gotta stay off the internet, you can't be fooling around with that at all.
Yes, sir, I fully understand.
Okay. Very good. Thank you very much.
And
Anything
Mr.
else we need to do?
Yes, sorry to interrupt. His arraignment is set for October 17th. I can just enter a plea of not guilty right now.
Okay, yeah, let's do that, and we'll come back in December, Madam Clerk. Matter of not guilty, and we'll come back.
I think he's already set for that December.
12/9 is what
He's already set for December.
Okay, December 9th. Okay, stay in touch with your attorney, okay?
Yes.
Thank
Well, yes. Your Honor, so I have, this is Aaron Fain, 2024 CF 690, 24 CF 707, and 24 CF 1633. I had inadvertently left off 2 counts in 2024 CF 690, so I've added them here. It doesn't change anything about the plea agreement. It's still probation. Everything else is the same. So you sign everything. Okay.
So what are we doing with those additional charges?
Yes, Your Honor. I was going to approach with it and then I'll.
Thank
you. So, Your Honor, counts 1, 2, and 3 of 2024 CF 690 are all possession of a controlled substance, the 3rd-degree felony, so they will have concurrent terms of 24 months probation, adjudication of guilt. So everything is exactly the same. The terms of the probation are also all concurrent with each other.
Okay. So, Mr. Fain, I'm, we want to make sure, the 2 things that I have to do when I'm asking these questions, one, to make sure you understand what's going on, had all your legal questions answered, and you're entering this freely and voluntarily. So I just want to make sure any questions of what's going on, the difference here, doesn't have any, end result is the same, but it's a little bit different. Have you had all your questions answered, and you understand
Yes,
what
sir.
we're doing here?
Yes, sir.
Okay. So it will be the adjudication of guilt, 24 months standard probation in 690, which is the only change. Those are the 3 felonies, and then the 3 misdemeanors in 690 are all credit for time served. So those are done.
Yes, sir.
Okay. The other things remain exactly the same. Okay. Any questions?
No, sir.
Everything else is the same, and you'll talk to Jim about
Mr. Medina.
Okay, thank you.
Yes,
Thank you,
Your
Ms. Parker.
Honor. I think I've got 3 pleas and 2 or 3 continued up, Your Honor.
Okay,
In any order they come out, I'm perfectly ready.
okay.
Yes, Judge. Scarlett Acosta is attorney. We have a plea agreement worked out. Ms. Acosta is, this according to the docket number is 2038.
Go ahead.
Thank you, Your Honor. Ms. Scarlett Acosta is before the court in 17 CF 2118. We have a violation of probation agreement that she's going to be signing, and we would like to also at this time resolve her misdemeanor new law case 24 MM 3417. That's an underlying paraphernalia case, and the state has agreed to resolve that at the same time. And she's going to sign the agreement, adding that in. So that'll be a no contest plea on that paraphernalia case, 24 MM 3417. That'll avoid her having to come back to court next week.
Okay.
The state's going to sign this, and there will be no score sheet because it's not an adjudication of guilt on the misdemeanor, not on the felony case, Your Honor.
You want to pass this being on through
Thank you. May I approach, Your Honor?
You may.
Thank you.
Thank you. Would you announce the?
Yes, Your Honor. In the VOP case, 17 CF 2118, Ms. Acosta is admitting to VOP. She's going to maintain her withhold of adjudication, so she won't become a convicted felon. There would be a reinstatement and modification of her supervision to add a special condition of 60 days jail with credit for all time served and with probation to automatically terminate upon release. So in essence, her probation's going away, but she has to serve 60 days jail with credit for time served. I don't know how much time served she has, but it seems like she roughly has a month or so remaining in jail. $100 VOP fee, $150 public defender fees, and monetary obligations will go to collections or lien 6 months after release. In the misdemeanor case, 24 MM 3417, there will be an adjudication of guilt, concurrent time served, an additional $270 in court costs, an additional $50 public defender fees, and as with the other case, we added an asterisk. The monetary obligations will go to collections or lien 6 months after release.
State?
Yes, Your Honor, did we announce that probation will terminate upon her release from jail?
Yes, it was a part of the promotion to automatically
Yes,
terminate upon release. Yes.
Ma'am, would you raise your right hand? Do you swear or affirm the information you're about to provide this court is the truth, nothing but the truth, so help you God?
Yes.
So you heard your attorney state the terms of the agreement. You're handling both cases, your misdemeanor as well as this VOP. And I see you've signed the plea agreement that's written that he announced from. Have you read this closely and gone over it with your attorney in detail? Had all your legal questions answered?
Yes.
You understand you're waiving the right to go to a hearing on all this. This will be a final resolution here today, and you're entering into this freely and voluntarily.
Yes.
Based upon that, the court will accept your plea on the felony count before us today, 17 CF, the VOP, 17 CF 2118. There'll continue to be a withhold of adjudication. Court will reinstate and modify supervision, that's probation, to add a special condition of 60 days jail. You will get credit for all time served, and probation will immediately terminate upon your release from jail. You got the BOP and the PD fees, monetary obligations. You'll have 6 months to pay after you get out, and then it'll go to collections. On the misdemeanor, there will be an adjudication of guilt on that. There will be concurrent time served with this. So you'll be able, when you get out, you'll be able to get out on both counts.
Okay.
$270 court costs and PD fees. And again, there will be an adjudication of guilt on the misdemeanor. Okay? Any questions?
No.
Okay.
Thank you, Your Honor.
Thank you.
Thank you. There you go. Good luck. And, Your Honor, her grandmother has been with her in the court all day waiting.
I was wondering who that was. Thank
Yeah.
you, ma'am, for support. Now, when she gets out is when it'll really start.
Thank you.
Thank you for being here.
Yes.
You're welcome to continue to hang around, but you don't have to. We always like visitors.
Your Honor, Kia Alloway is before the court for arraignment in 24 CF 1744. He will plead not guilty in that case. He also has another case, 24 CF 1306, where he's already pled not guilty. If everything could remain on the October 16 docket, I'm going to be getting with him with...
Okay, well, hold on a second. You announced a case. I've only got one case before me.
Yes, that's right.
Is there one this afternoon?
No, Judge. The other case he had already pled not guilty in, so it won't be on the docket for today.
What I've got is the 24 CF 1306 on today's docket.
Your Honor, I still have the 24 CF 1744, which was supposed to be an arraignment on a new charge.
Oh, I think that's what it is he's on both dockets. He's on the afternoon docket for 24 CF 1744. I think it was basically a holding status, more or less, just in case we work both cases out. But
We got a no, not guilty on this afternoon's charge on the 17.
Yes, on 1744. I apologize, Judge.
That's all right, and we'll come back on both of these on, we on the December pre-trial?
He's on the, no, he was already on October 16 docket, Your Honor.
Not October 16th. Yeah, October 16th, you're correct. So October 16th, we'll continue to October 16th on the 1744 24 CF, and we'll also continue the 1306 to the same date, October 16th. Correct?
Yes, Your Honor, please.
Okay.
Yes, Your Honor. There are many things that I met with him yesterday that I'm going to be working on with him. So he's providing me, just for the awareness, just some papers that we went over yesterday. He's given me, and I'm going to copy them and give them back to him. Thank you.
Thank you.
Appreciate it.
Yes, sir. Thank you.
Sorry for that confusion, Judge.
All right. Barrios.
Your Honor, Mr. Barrios is before the court, Elijah J. Barrios, number 40 on the docket. And we have a BOP agreement in the 4 cases that are on the docket. That's 16 CF 2941, 16 CF 2942, 17 CF 2982, and 17 CF 2983. And he is signing the agreement. You can keep that. You can keep that. And I will be approaching with a score sheet as well as the agreement, Your Honor. It's the same thing. That's where you sign. And Your Honor, Ms. Sharpless is signing it for the state.
Yes, Your Honor.
It's going to be done. approaching, if I may, Your Honor.
You may.
Yeah, I did need to show him this score sheet. I'm sorry, Lieutenant Chief. He's not scoring DOC. Your points are 38. And it is not a downward departure because he's not scoring. Your Honor. Thank you, Your Honor. Your Honor, under the terms of the agreement in these 4 cases, the defendant is admitting violation. He was previously adjudicated guilty. It will be revoked and terminated. Credit for time served, $100 VOP fee times 4, $450 public defender fees, monetary obligations to collections or lien. That is the agreement, Your Honor.
Take.
That's the state's agreement.
Mr. Barrios, would you raise your right hand, sir? You swear or affirm the information you're about to provide this court is the truth and nothing but the truth, so help you God?
Yes, sir.
And you said Mr. Medina, that you're okay with the score sheet?
Yes, Your Honor.
So you heard your attorney state, probably the simplest plea agreement we have today. So you got four violations, felony violations of probation. You were previously adjudicated guilty. Court's going to revoke and terminate. Your actual sentence is credit for time served. So you can get out. You're not going to be on probation. But you will, always get the fees and costs, $100 VOP times 4, and the $450 PD fees, and those will all go to collections. Okay? Any questions?
No, sir.
Okay. Thank you.
Your Honor, Mr. Tyrone Brantley's approaching, and I wanted to note a couple things. In addition to having the agreement that's going to resolve his cases, this moots the need for him to have a motion to compel hearing that was set for today.
Okay.
It also moots the need on, I believe it was September 17, he was going to have a VOP evidentiary hearing. That's going to go away as well pursuant to this agreement, Your Honor. Take that off. You ready, son? And I'm sorry I don't have a copy for probation, but it's pretty simple. And I'll be approaching with the score sheet, which I'm showing him. May I approach, Your Honor?
You may.
And I was noting to him is there have been some complicated hearings that I've researched in the past relating to some score sheet issues. To the best of my knowledge, there aren't any inappropriate prior record references, but I did raise that with the state. He doesn't wish to belabor the matter. He wants to go ahead and resolve the case. I do not question the score sheet, but I also would just put on the record that he's wanting to get it done today. We don't have all the certified convictions backing up everything, but I did research the issues the best I could. I informed the state of that a couple of days ago. That's it. That's about it on that.
Okay.
Under the terms of the agreement in 23 CF 1992, he was previously adjudicated guilty. He's, of course, admitting the violation. There will be revoke and terminate. 10 months Okaloosa County Jail with credit for all time served. He believes the amount of days he has is what did you think it was?
249.
But there's all sorts of questions about whether the jail will get him some good behavior credit, and that's not necessarily exact, but there will be $100 VOP fee, $150 public defender fees, monetary obligations to collections 12 months after release.
State?
That is the state's agreement, Your Honor. This is a downward departure, but it's based on a legitimate unwarranted party.
Okay, very good. So, Mr. Brantley, would you raise your right hand, sir? Do you swear or affirm the information you're about to provide this court is the truth and nothing but the truth, so help you God?
Yes, Your Honor.
So, you heard your attorney state the terms of your plea agreement, and I see those same terms are in the written plea agreement. You signed it. So I just want to make sure you read this closely and gone over it. I know you've been in close communication with your attorney. You've been a very strong self-advocate throughout this process. I just want to make sure you had all your legal questions answered about this plea. Have you had all of your legal questions answered regarding this plea agreement?
Yes, sir.
Okay. And you understand that by entering into this plea agreement, you're waiving the right to go to a hearing. This will be a final resolution of your VOPs. Do you understand that? Is that what you want to do here today?
Yes, sir.
Nobody threatened, coerce you to get you to enter into this?
Yes, sir.
Okay. Very good. Based upon that testimony, the court will accept your plea agreement here. And you were previously adjudicated guilty on all counts. The court here today will revoke and terminate probation. You'll be sentenced to 10 months in the Okaloosa County Jail. You will get credit for all time served.
Yes, sir.
And you'll have, of course, they always hit you with the fees, the VOP, $100, and $100 PD fee. And the monitor, you'll have 12 months after you get out of jail to pay these fees, or it'll go to collections.
Yes, sir.
Okay? Any questions?
Yes, sir.
Okay. Thank you.
Thank
Good
you.
luck. Good luck.
Thank you.
Your Honor, Ahmad Braxton is approaching. Mr. Braxton is number 42 on the docket. Cases 24 CF 144, 24 CF 154, 24 CF 1189, and 24 CF 1328. Mr. Braxton's been accepted to Phoenix House. We've been hoping to work out an agreement with the state for Phoenix House. As of yesterday, the state was not willing to do an agreement to Phoenix House. It was suggesting a plea to the bench. The problem with that, from his perspective, is he desperately wants inpatient drug treatment. And his score, if all the charges stick, would be more than the 60 points. So that would make a plea to the bench problematic for giving him eligibility to potentially go to Phoenix House against the state's recommendations. So I'm going to do my best to talk to Ms. Sharpless about whether we can work out a plea to the bench that would give him a fighting chance to go to Phoenix House. And regardless, we'll put things on whatever posture they need to be on by October 16, Your Honor.
Okay. So we'll continue the matter. So what we're doing here today, just continuing the matter to the 16th, and I do understand the kind of the state of the negotiation.
Yes, Your Honor. Today was just a status because we were hoping we could do a deal today, but we cannot.
Okay, so we'll come back on October 16th for be pre-trial, and hopefully we can get some resolution at that time.
Thank you, Your Honor.
Good luck.
Thank you.
Your Honor, next is Jose Briones. Mr. Briones is number 43 on the docket, 20 CF 1568. He also has a new law case, and just for the record, his new law case which is not on the docket today, is 24 CF 1302. So in the VOP case, 20 CF 1568, he will like to enter a denial today and keep everything on October 16th, retrial. And he has met, and I did talk to Terry Henderson with drug court today. He's had a communication with her, a meeting with her. She has to go through channels there. I don't know if we're going to be able to work it out, but he really, really wants to get treatment for his apparent alcoholism, Your Honor.
Well, the drug court is a very good program, and hopefully you can get that worked out. So on the new law charge, 24 CF 1302, you said that's not on today's?
That is not, Your Honor. He had already had arraignment on, I think, July 11th and entered a plea of not guilty.
Okay, he's already done it.
Yes, Judge.
So both these cases are coming back on October 16th?
Yes, Judge.
Okay, very good. So we'll continue both the cases. We're continuing this case, the other one's with us.
And there's
October 16th without subpoena.
There's some other things I'm going to work on, getting him an evaluation for mental health because he lost his son 2 years ago, I think to a violent crime, so there's a lot of dual diagnosis issues, I think. Thank you.
Okay, very good, good luck. Okay, so that concludes our business for this morning. It is 12:39, so we'll probably start